Justice were kind enough to issue notice on 4th August, my lords. However, the CIRP has been continuing, my lords.
Admitted, is it?
It was admitted, my lords.
Appeal is admitted.
No, appeal is not admitted. The CIRP was admitted. I went to NCLAT. NCLAT, this is my appeal.
Date. We'll give a date. Next.
My lords, I moved an IA. IA could be listed, my lords, for interim leave.
With IA के साथ लगा.
IA 685.
20th of March, second one. 20th March.
Please, my lords.
Out of 60 matters,
20th March.
802.
20th March.
10th March, the bail is expiring.
20th March.
10th March, the bail is expiring. 10th of March, the bail is expiring.
Okay. We will extend it right away. What is that? We will extend it. Was it an ex parte order? Grant of bail was ex parte order?
All the states were, they had no objection, basically.
We are saying when we passed that grant of bail,
Please,
was that an ex parte order or after hearing the other side?
The other side had appeared, but they had no objection as such. Please.
The purpose is served.
The purpose is served.
With my lord's permission, may I make an unlisted mentioning? My lords, this is for listing of two applications, procedural applications for deletion and substituted service, my lords. The registry is not listing it without a court's order. Because it has to come up before the registrar and the learned chamber judge respectfully.
Check करके बताना. We'll just check it up.
May I have your lordship's permission to mention a matter, my lords? Your lordship would recall these are these Madhya Pradesh reservation matters which my lords had heard and remanded.
We are listing them for clarification.
Your lordship, one of the Chhattisgarh matters was tagged, my lords.
We are getting clarified.
Very well.
We could have done it in the chamber, but it's in the open court. Some small correction will carry it out.
Very well.
We are getting it listed in a day or two.
I'm grateful.
I'm seeking liberty to mention a matter, my lords. Both the connected matters were listed on mentioning list, my lords, on 20th February. My lords directed both the matters to be listed on 10th of March, my lords. But only one matter is coming up tomorrow, my lords.
All right.
Because the order does not reflect the other matters, my lords.
All right. दूसरा भी लगा देना. Next.
Obliged.
Item 1.
1 minute. But now, there is a development. But they are filing.
It is appearing?
Yes, my lord. I beg to appear, my lord.
So now, final report has been filed dropping me as an accused.
So then,
they may file protest petition. Therefore, the interim protection given me.
they have already granted you entry protection.
It is there, may continue. The petition may be disposed.
What do you say, Aishwarya? This
Yes, my lord. So there are two petitions. One, father has not been made an
both the
accused.
matters we can dispose of, no? Confirm that interim order and dispose of
So
it.
the son has made an accused, but but the interim order may be confirmed, my lord. I leave it to your lordships.
What do you say? Yes, Meena. ये नो इसको allow कर देना.
Please.
Be granted. The SLP is against the judgment and order passed by the High Court on 11/3/2024, dismissing an application for anticipatory bail. So, the circumstances in which the order impugned was passed has by now changed by passage of time. Stop. In any event of the matter, while issuing notice on so and so, we had granted an interim protection, and the same order is continuing till date. In the facts and circumstances of the case, we are of the opinion that the petitioner should be entitled to grant of anticipatory benefit of anticipatory bail. In view of the next paragraph, in view of the above, we allow the appeal, set aside the judgment and order passed by the High Court. In the event the petitioner is arrested, he shall be released on bail subject to such conditions as may be passed by the trial.
Great.
Thank you. Thank you, Aishwarya.
In compliance of order dated 26th of September, I joined the investigation on 14th of October.
Counter we have filed, counter on behalf
Order
of.
has been filed by the state.
Yes, yes.
To be done in this
Millet,
anticipatory bail.
please, minutes. At page 7, I joined the investigation pursuant to my lord's order.
Same order कर सकते हैं ना? Who is appearing?
Millard, I am appearing for the state in this case.
What do you say?
Millard, he has.
Will confirm that interim order.
Millard, 50% amount the learned session court has asked him to deposit, but he came here because he didn't. His bail was dismissed on this ground.
PSCL matter.
Yes, Millard. That is the only
When was
reason.
the interim order granted to him by our order?
26th of September, my lord.
September last year.
Last year.
What do you say, Mr. Maninder?
Lordship may confirm subject to Milord some Milord amount he may deposit for the illegal use of the Milord the electricity which he has used for his.
That's the whole issue, Milord.
Illegally, but he's filed a suit, I suppose.
Milord, that suit has been
That
filed.
is for a different
That is
different
what-
vehicle.
Forget about it. We'll leave it at that. What kind of an interim order in a bail matter? What kind of a money should we insist?
Milord, because it is a compoundable offence, so that is why the Honorable Learned Session Court has granted 50% amount be deposited. And
Deposit
he,
some money?
that was the only reason.
That's a reasonable one because
Not reasonable.
Milord, the trial court has
How
asked
much
you to
is the
deposit
money?
50%
21
of-
lakhs. 21 lakhs.
The 50% trial court has,
Those recovery proceedings?
Milord, that would be there, but
No. Are there any recovery proceedings?
yes,
you have
yes, Your
to-
Lordship, there
There are two things. One is the recovery proceeding, another one is the filing of the
Yes.
suit.
Yes. Milord, recovery proceedings are there. The PSPCL can recover it. So the other thing is, Milord, the trial court has also stated that 50% amount out of 21 lakh he deposit and 1.5 lakh was the compounder. He is not ready to do that.
You deposit.
That was
Milord, what has happened? May I just explain, Milord?
Don't use this as
Milord,
a...
that meter stands in my name, Milord. I was
No,
regularly
no.
paying the payments. Look at page
Tell us,
42 for a
we are
moment. Milord.
granting you bail, so... Except for that portion of the order, we will set aside the High Court's order and we will ask you to be released on anticipatory bail. Right?
Please, Milord.
Is that all right? इतना बड़ा order pass किया High Court ने. Where is the trial motion? Accordingly, this court. Where is that amount deposited?
The notice
No,
is
sir. Where is the direction?
Milord,
that
that
is
was
there.
the
On page 69 of the petition.
Page 69. What order is that at 69?
Well, it was passed by the learned trial court asking me to deposit 50% of the demand notice.
Initially, that?
Initially, Milord.
initially. Yes.
Not by the High Court, Milord.
In the criminal case?
Yes, in the FIR case, Milord.
In the FI, this case only, Lordship.
What is the date of that? 4th of August 2025.
4th of yes, Your Lordship.
Additional
Okay.
section.
Milord may have page 69, Your Lord.
That
So
was,
next-
however, the anticipatory bail was dismissed for non-compliance, is it?
Page 71, Your Lordship. Page 71. P8.
No. 71, was it for non-compliance?
Yes,
Yes.
Your Lordship.
Okay. So you deposit that. All right. Yeah, first paragraph, लिख लेना. Same order. Same thing against the judgment and order dismissing the anticipatory bail on 29/8/2025. While issuing notice on so and so, we have directed as under quote कर लेना अपना order में. Stop. It is evident from the from record that on 4th of August 2025, the additional sessions judge Ludhiana had directed the petitioner to deposit 50% of the disputed penalty amount as a precondition for grant of anticipatory bail. However, due to non-compliance, the case came to be dismissed on 12th of August 2025. The High Court, as indicated here and above, has also dismissed the anticipatory bail application by the order impugned before us. This paragraph, the learned counsel for the petitioner would submit that his client will be willing to deposit the 50% of the penalty amount, accepting his submission. We direct that the said amount shall be deposited.
Oh, which means-
Where? Which court? In which
before
are
trial
those
court.
proceedings? Huh?
Before the proceedings, pending before the trial court, Milord.
Which proceedings is what you are asking?
Milord, it would be a special
The
court.
charge sheet has not been filed, Milord, in this matters.
No, that recovery proceedings are before which court? Not about the criminal case.
No, Milord, criminal case is pending.
The suit was filed by us, Milord. The recovery proceedings have been initiated by them, by the department, Milord.
Where shall we ask him to deposit the money?
Milord, with the department only, Milord.
No, we will ask them to deposit in the account of the suit.
Please, Milord. Then
Okay, that should be better, right?
Please.
Okay. That suit is better than some proceedings you should deposit. Before
But
in the
let's, that civil suit is for the injunction that has been filed by me
Yeah,
with respect to the another electricity meter. That was the
some other.
yes, Malaj, not with regard to.
And where will you deposit the money?
As Malaj say, if Malaj would say,
We are disposing of this case, Mr. Maninder Singh. Where do you
Milord, he may deposit with the department, Milord, PSPCL, Ludhiana.
not? Have you initiated proceedings for recovery?
No, no, not yet, Your Lordship.
Give the deposit.
Milord, he would get a receipt for the amount, whatever he deposited, he would get a receipt from the PSPCL department.
Malaj, once the amount is gone, Malaj,
What-
Malaj, that's the whole tribal issue here, Malaj.
Milord, because he has been using the electricity illegally.
Malaj, what has happened here? May I just
on his
explain?
commercial unit, Milord.
In the car, with the government, we will put it in your account, your suit, right?
Please, Malaj.
For the suit ka number le lena.
Page 52, Malaj.
Page 52.
CS number 42777. 4277.
Before so and so court, in the account of CS number 4277 of 2025.
2025.
Pending disposal of the suit. Full stop. Subject to such deposit within a period of 3 weeks from today, we confirm the interim protection granted to the petitioner. In the event the petitioner is arrested, he shall be released on bail subject to such conditions as may be imposed by the trial court. With these observations, the civil appeal stands partly allowed. Thank you, Mr. Maninder Singh.
Please, Your Lord.
Yes.
No, this contempt is filed, my lord, of the order of 20. I'm sorry. Yes, nothing has to file. His laptop is not working. Yes. My lord, contempt is filed, my lord, of the order of 16th February 2010. Your lordship will have that at page 54. Page 53, at page 54, my lord, paragraph 5. My lord, a review petition has been filed by us against this impugned order. That is not being listed, my lord, for the last 5 years. No,
The ineligibility is 2018 and you file a contempt petition in 6th of February 2021.
Lord, because they are supposed to give us possession. This is, my lord, a school being run for Adivasis in the Sanjay Gandhi one. We are supposed to be relocated into another premises.
A case for contempt.
No, my lord, conservator of forest records that we are eligible for
You are
allocation.
entitled to enforce your rights, but not a case for
So
contempt.
kindly see the sequence of orders, my lord. 2006, my lord, your lordship will find at page 25, the conservator of forest is required to determine whether I am eligible. He finds, my lord, at 12/5/2006 at page 32 that I am eligible. Based on that, my lord, this 2010 order at page 53, where SRA says, my lord, the moment the building
While
is completed,
disposing of the writ petitions,
Yes.
directed to hand over possession of the building being constructed upon
Yes.
its completion.
And
That's
it's
only a disposal order, no
it's
execution.
completed, my lord, and the SRA doesn't give me possession, saying the conservator of forest requires to review his earlier decision. The decision, my lord, is part of the court order.
These are not. These are not.
Lord, I hope I make myself clear, my lord.
These are not judgments and directions. Which
Will I kindly have-
final. While disposing of, you consider jurisprudence. We have just recently given a judgment. This consider jurisprudence can't lead to contempts like this.
The consideration was earlier by the conservator of forest, which
And
he
in
has
the
done.
event of the matter, just tell us one more thing, Ritu.
Yes.
6th February 2010, the so-called order in your favor.
Yes.
And in February 2021, you file a contempt.
Because, my lord, the building is being completed. When the building is completed, But when the building is completed, the slum rehabilitation authority does not give me possession.
No, no, you're
Saying
not
that-
right. You're not right.
But
We'll
kindly
tell-
have the impugned
We'll
judgment.
tell you why.
Yes.
We don't want to interrupt you, but then the conservator of forests wrote a letter way back in 2018
Saying that I am-
saying that refrain from taking any action
Yes,
on rehabilitation, not being eligible for rehabilitation because
I'm very grateful.
they say you are not one of those who will be eligible.
I'm very
And
grateful.
when that became evident, you could have availed your remedy then itself.
No,
You
no,
couldn't
kindly
wait
have
till
that
21.
letter of 2018 because what the conservator of forest is saying in that letter is that the eligibility I found in 2006, I intend to file a review petition to recall that order. But if your lordship will have the 2018 communication,
Case for contempt.
no, no, kindly,
Particularly when High Court.
I have
itself
no
is-
remedy left, my lord. 2010, they are supposed
That's your
to give
choice
the-
you made.
But your lordship, let me press the review petition then, which is pending.
We'll keep it open-ended for you. While we are not inclined to entertain the specially petition against dismissal of the contempt proceedings, rejection of contempt proceedings, we keep it open for the petitioner to adopt such remedies against.
Your lordship, there's a review petition pending.
Then what you want?
24342
to
in the
dismiss
High
it?
Court.
You want to be dismissed or withdrawn so that you'll pursue your remedy?
Yes.
Dismissed is withdrawn.
But with
To
liberty to
pursue,
challenge this order.
the
Review
pending
petition
review
number
petition.
24342,
To pursue the
review petition.
review petition which is set to be pending before.
Yes, but not with liberty to come back against this order in case the review is
liberty.
rejected. Your lordship may record that.
The review is against which order?
Against this impugned order.
Contempt again.
No, no, my lord.
That's again a contempt order.
Yes.
You are not saying that. We will not touch that. Listen
Because
to us.
otherwise the review I would be
Listen
able to
to
come
us.
against
You
this
are-
order.
yeah, If we well, our objection is with respect to your initiation of contempt proceedings. Contempt dismissed, we are not inclined to accept any argument that your relief can be through contempt. But still we are saying if you want to file a separate independent writ petition
Yeah.
or a suit or whatever, you may pursue that, we will keep it open for you. You pursue your review also, we are not interrupting that.
Very good. Your lordship.
Okay. पहला वाला order दे देना while we are not inclined to entertain the specially petition against the dismissal of the contempt proceeding. We keep it open, the petitioner will be entitled to adopt such remedies as may be available to him in law through civil proceedings. Plus,
Obliged, my lord.
about
These are my lords, engineering analysis,
Yes.
both 4 and 50. You
Thank
can hand over the order. We filed all these on the belief that there was a.
similar
review
matters have
pending.
already been
There
discussed.
are. You can hand. Good. 50, same.
Yes.
Lordship, this city corporation has nothing to do with the national highway, and together can't be.
What is this?
No, Lordship, can't be directed all to pay. At least it has to be said who has to pay.
Land taken from road.
No. Lordship, road widening, national highway. This was from the beginning. It's a national highway. Kindly see first trial court dismissed the suit.
Just a pay 73 lakhs, that's all.
Lordship, it's not question of 20 lakh. Who has to pay is the question. I'm a city corporation. State has.
You are joint in civil.
No, Lordship, no. I have nothing to do with the national highway. It's the national highway handed over or directed the PWD to carry out the expansion, road widening, and the PWD has carried out. And now all together pay, whether the state will pay, because I'm a corporation. I receive the funds that I utilize for specific purposes. I have no funds for paying this one. The
Have you
PWD.
filed a execution?
Pardon, yeah, they have filed execution, 50,
that-
execution 50 of 2026. My
will
car,
say-
Lordship, commissioner's car, table, everything will be attached. This will be taken out.
Will be or has been? No? Yes.
National Highway Authority is also dependent.
Yes, but because National Highway is, said that the expansion will be carried out by the state, so it has been exonerated. National Highway has been exonerated. PWD was directed to carry out. The state was directed to carry out the widening. So the state carried out. But I was wrongly made a party.
You are
So
not
now
wrongly
all the
made.
defendant 1 to 3 will pay. That's the order. Kindly peruse the.
Several liability.
But
Joint and several liability.
but I am a corporation. I receive the funds for specific
In any
purposes.
event, the executing court will decide who has to pay.
Lordship, they will simply come and attach my property. My car, table is a very usual thing to do in the trial court. So it's a corporation. the others will come and.
All right, dismissed.
Lordship, the state will prefer.
You have your remedy before the EP court. Thank you, dismissed. 6.
Your Lordship, this is my SLP against the order dated, my Lord,
LP
judgment
in
dated
High Court.
27/11/2025. Wherever my Lord, my
This is the same matter, no?
dismiss, my Lord. My Lord, I want to
This is
bring.
this is that matter, no? Covered by. That Sundaram Finance says so.
My Lord, Sundaram Finance is silent on the aspect that regarding the central core banking system, my Lord.
Regarding what?
Core banking system, my Lord. Since the banks have been centralized, my Lord, each and every branch is capable of all type of transactions. My Lord, the concept of home branch has become redundant.
You filed it where?
My Lord, I had filed it in Himachal.
Himachal Pradesh. They say they asked you to take it to.
Yes, my Lord. And that also after period.
They asked you to take it to where?
Yes.
Where the property is situated. Where is that?
My Lord, that is Kerala. And my Lord, in my case, my Lord, attachment has already been done. Highly obliged. Highly obliged.
Stamp duty.
Lordship, in item 8. Lordship, may I pray for stay because
Stay. Not.
grateful.
Direct. Money share.
Manoj, in this
Is
appeal,
that SAT matter?
yes, Manoj. I have no role actually. It was my.
How can you escape?
No, I'm not a.
How can you escape? You are all just because you say my brother did it without telling me. You are a director.
I'm not, Manoj. It was in 2008. I'm being his elder brother, younger brother. I've signed the document. That's all. My role is very minimal.
That won't work.
My lord sees the
You
SAT.
are a director, sir.
Yes, I was in 2008. I do a different business. I'm with my father doing a different business, Manoj. I was there just for the support of my brother, and that has been observed in the SAT's order. FIR was registered against my elder brother, and not on me. And unwantedly, my bank account has been
Not
freezed.
like this. Thank you. Dismissed.
May I please, my lord, against the relied upon judgment, my lord, notice has been issued by your lordships in diary 618.
It only followed ITAT number 1184 of 2006.
that is-
What happens to that?
That is in the civil appeal diary,
Oh,
SLP
that's
diary.
Oh, you filed an SLP against that.
61839 of 25. Your lordships ordered notice in that. my lord.
In that is that.
There is one distinction, my lord, I'll like to point out.
No, but then in the other matter, we have
Lord,
to-
that's why this
Between
is
this and that is
your assessment year 97, 98.
Ah.
Here, my lord, ultimately in the base tax, the court held that substantial part is not exigible to tax. They came in SLP dismissed in default in 2017. So why should your lordship interfere? That order is not final. If, Lord, the High Court holds that substantial part is not exigible to tax, why penalty, my lord?
Lord, your lordship sees the impugned judgment.
In the other matter, my lord, matter is pending in the High Court. In that matter, my lord, for 97, 98, for which, my lord, this SLP is.
271.
The impugned judgment relies on the relied upon judgment.
So he's saying that substantial part.
No,
is
that part is, my lord, that is challenged in the other SLP. Let the both of them be tagged. We can
post along with that.
oblige.
We'll just ask it to be posted along with.
Very well. I'll place those orders on record, my lord.
Post along with.
Great.
11, my lordship, is 35L appeal. So I have challenge on predominantly 2 counts.
Clear remand order.
Certain portions of remand is pending adjudication before commissioner, but 2 aspects. One was reconciliation, second was sponsorship fee. So for the first portion,
Wait a minute,
my lordship, what happened? The first annexure, the one important annex. So far as my first challenge is concerned, one important annexure is missing in the SLP. I may be granted 2 weeks time and place it on record. That may be had relevance bearing in the first.
Adjourned by
Great.
weeks to enable 2 weeks to enable the petitioner to bring additional documents on record. Yes.
May it please, Millets. Millets, a scheme of compromise. I'll just give one sheet, Millets. Kindly have a look at the terms of compromise. I am a dissenting minority creditor.
0.26%.
Millets, my only grievance is I am bound by whatever that's been decided under Section 230 of Company. But at the same time, I should not be shut out of my remedies if they are available under other statutes. For example, Millets, MPID. More than 2,200 crores of assets have been attached under that one. And the company code says, Millets, I should not oppose even their application for quashing and other things. Before PMLA, before MPID and every other forum, I should not oppose. That hurts me. I could understand within that statute regime, I am bound.
That we understand. But then what stage? Now at this stage to permit you to go to other proceedings and all.
They have
that
already been pending even much earlier.
Averted now.
Millets, much earlier, the attachments have taken place. They have come to your lordships. They have challenged that it's been repelled. My lords have said, no, it's an independent proceeding that has to go on. Now with this one, that's been nullified. I am remediless. My lords have held many a time when I have got other remedies beyond that statutory scheme that cannot be affected. All that I want from your lordships is that liberty to pursue my remedy. My lords may kindly see, the assets attached was more than 6,000 crores.
Where are they pending?
I quote, Millets. Attachment made, amount deposited. And if in my suit.
But here, how are we? We will only say that so far as the High Court, this NCLAT is concerned.
Yes, Millets.
It has what he has, other than more than anything, it is
that remains unaffected.
Saying that so far the scheme is concerned, substantial compliance is there, and 91.35% have already accepted it.
Agreed, Millets.
So to that extent, then
I am not coming in the way, Millets. I cannot, brother.
What I was saying is,
Millets, two things, my lords, may kindly appreciate. My suit is pending, where attachment has been effected.
How does this prejudice that?
Millets, it's been said in the scheme. I cannot oppose. They have to be. I have to cooperate with them. Straight away, kindly come to page 748, Millets. Page number 748. The NCLT, which has been affirmed by NCLAT, kindly come to 748, para 41. Kindly come to that one. All that we want is that, no, kindly don't touch that one. That's my humble submission. Other remedies remain intact. I can pursue them. Kindly have a look at page. Millets, my lords may kindly see some statistics here. 6,000 and odd crores is the attached property. The amount defaulted is 4,500 crores. They have settled with the creditors majority 1950 crores. And when it comes to my case, in 2013, the due was about 12.25 crores. Now that has ballooned up to whatever the figure. Properties have been attached and much more than what is that. It says that once this 1950 crores paid to these people, everything else go back to them. Whereas the attachments have attained finality, your lordships have refused to interfere. In all these aspects, that remedy is to be preserved for me.
For R1, what
This
is not,
particular concern of
yes,
his.
yes. What is not told to your lordship is interesting. This is 0.26%, my lord.
0.26%, correct.
91% have
We have
approved.
noted that.
Yeah,
91.35% have agreed.
7% out of 3,000. No, just load two things. I'll not open the pages. Under 234, unlike your lordship's amended 241, there is no waiver. It's an absolute bar. 5% they've kept from 10 to 5 with no waiver. Number 3, these same people, 7 out of 3,000, have gone in a writ with identical prayers. Number 4. Well, number 4.
Not
findings.
identical prayers,
But,
my friend
sir,
could
I
demonstrate.
didn't interrupt you, Mr. Naidu.
It's not
I
correct.
didn't interrupt you, Mr. Naidu. Now, 4. My learned friends have concurrent findings against them. They want only one word from your lordships to destabilize the whole scheme. Supreme Court, any single word. It's a huge impact, brother.
Shows that writ petition prayer.
Yes, yes. Please give that annexure.
prayer.
Come on, give it.
Shows that writ petition prayer.
Annexure B is there. It's here in this note. Volume 2, page, Willis. Volume 2.
There's no.
Page 889, volume 2. All this, Willis, why should your lordship interfere?
Prayer.
842.
879 are the prayers.
Volume 2.
879.
Yes, so-called volume 2, Malas. And the law, Malas, established that any scheme binds all.
Just read the prayer.
Even a 50%, I mean 49% minority is bound.
Yes.
In the aforesaid circumstances,
Order
I'm sorry, Justice Radhe doesn't have it.
No, you are watching here.
That this honorable court
deemed
a
appropriate.
writ of certiorari or writ in the nature of so and so may be deemed appropriate by calling for the records, etc. of the affidavit. Now read B, Manas, B. This honorable court be pleased to issue a writ of mandamus as may be deemed appropriate, prohibiting R1 and R2, that is me, Manas, releasing assets of 3 and 4 attached under 4 of the MPID or supporting, consenting to, pursuing or facilitating in any manner. Now it's very clever. Today he is making a virtue which he never argued before. The sweet reasonableness of Mr. Naidu will not change his client's stand.
Yes. I'll just contradict that one. How fallacious that argument? I'll demonstrate your lordship.
755, page 755, my lord, which is the order of the NCLT. It protects what my learned friend is saying, my lord, they have an apprehension about. My lord, please see para 56, page 755.
55.
Page 755, this is the NCLT order, para 56, affirmed, my lord, by NCLAT. It says, all the requisite statutory procedure has been fulfilled. Company petition is made absolute in terms of the prayer. However, it is clarified that the sanction of the present scheme shall not in any manner override, dilute, or affect the operation of any subsisting attachment orders issued by any court, tribunal, authority. Same shall
My lords may kindly see, this is one thing.
But two,
My lords,
the
what's been
sanction
said?
of the scheme
Yes.
shall not be construed the quashing, withdrawal, or termination of any criminal proceedings pending before any judicial, quasi-judicial, or other competent authorities. It also notes, my lord, that EOW authority
Even without that, it would have been, but then they will take into account this, but doesn't matter, that they will handle it on their own.
They say Supreme Court is
All right.
That's all we wanted, my lords. My lords may kindly appreciate one thing. My lords, may I just have 1 minute, my lords may kindly have it 1 minute. My lords, it's been said, what's been said is that the scheme has been approved in the first place. Now they have given a caveat over there. The meaning of that, in my humble submission, is, Millets, I cannot oppose that one, whereas the authorities can pursue it.
Right,
If when it's for my benefit, Millets, how could that be? Millets, all that I want is, Millets, kindly one observation that my other remedies are intact.
Particularly in cases like this,
Millets.
one word will make world of
No, Millets, my lords may kindly appreciate. Millets,
Okay, Mr. Naidu.
Millets, 230, would it defeat the rights under the MPID, Millets? That cannot. That's all we wanted, Millets.
Too far for this. Thank you, dismissed.
Grateful, Millets.
It's come too far. Valiant effort.
May it please, my lords. My lords, item 13, my lords may see page 20. The tribunal, my lords, relies on...
Differential duty.
The tribunal relies on the judgment in Neeraj Silks. Your lordships have entertained the appeal against Neeraj Silks. Notice has been issued. May I just pass the order?
Same.
It's the relied upon order at page 20, my lords.
Neeraj Silk, no?
Yes.
They relied on Neeraj.
So that has been appealed, my lords. Notice is issued in the matter. Very grateful. That's 14, 730 days delays. May dismiss it on delay.
Yeah, dismissed on it.
Very great.
Let item 15, we'll have a
Power of
well-reasoned
attorney.
judgment. Yes, we'll have a well-reasoned judgment of the learned trial court. Learned trial court discusses.
He doesn't have a power of attorney. Okay, you will succeed if you answer our question. Is there anything in the agreement which permits it to be subleased?
Millet can kindly see annexure P1, P2, P3 also.
Does
This
the
was-
contract prohibit a sublease?
No, Millet, it is not there.
Does it permit a sublease?
Millet,
answer it yes or no.
Permits. Millet can kindly see.
Show the clause.
Yes, Millet can kindly see P3.
Show the
And
clause.
P1 first, Millet can kindly see P1 first. Which
Just show the clause.
Millet, there is no detail context. Millet can kindly see P1.
In case it's a open
Millet can kindly see P1. It is given by the superintending engineer PWD. Same authority, Millet. P3, Millet may kindly see. The superintending engineer PWD Western Circle so and so hereby acknowledges, accepts and approves the power of attorney. Millet can kindly see P3, Millet. It clearly accepts the power of attorney. P3.
You're right.
First paragraph, my lord,
We thought we also.
claim authority.
We also. There is one letter, brother. You know, you want a letter. Few power of it. My brother is asking you.
Yes, please.
So even assuming that you have a locus, the finding is that there is no evidence that any substantial work has been done.
Correct, my lord.
Number
My lord
one.
can kindly see
And secondly,
P8.
there is no
Lord can
evidence
kindly
with regard to quantifiable claim.
Can kindly see P8. There is a report, local commissioner's report. My lord can kindly see that, my lord. At page 91, page 91, my lord. And it gives a detailed inspection report of the site that the work was and totally ignored. Local commissioner 91, my lord.
We'll issue notice.
Much obliged.
We are not very certain, but
Deeply obliged.
we'll
Let
see.
me kindly condemn
will
that
see.
there is a short delay, my lord.
Notice. Let them come other side. Notice also on delay.
Much obliged. Much obliged.
Please, Your Lordship. Wait a minute. It is the challenges. Ownership never a question. He gave a finding with respect to title of the property. That's what he said.
Evidence is on record is sufficient.
Your Lordship, the respondent is the original plaintiff, Your Lordship. He filed a suit for recovery of possession and recovery of arrears of rent, Your Lordship. Whereas, Your Lordship, the High Court has given the finding on the ownership. Your Lordship, the first appellate court, after going to earlier, Your Lordship, trial court has rejected their suit partly, Your Lordship, to the extent of possession of the suit.
Only arrears gave.
Arrears has been given. First
And
appellate
he
court
filed
has.
an appeal.
Yes, Your Lordship. First appellate court, I have filed
You filed an appeal.
regarding the recovery of Your Lordship.
And they allowed, and even arrears they didn't give.
Yes, Your Lordship. Whereas High Court
He
has
was-
completely High Court has confirmed the order, but as regards to ownership is concerned, Your Lordship, the High Court has given finding on that part.
To remove that observation of ownership.
Because my specific case, I have denied his ownership, Your Lordship.
That is right. In the first appellate court,
Please, Your Lordship.
there was a finding.
He is not the owner.
He is not the owner.
Your Lordship, his contention is that on the relying upon the sale deeds, Your Lordship.
That's also his suit. No.
By first appellate court, Your Lordship.
No, impugned order.
Impugned order. Your Lordship may
Did they
kindly
give
see
a
the
proper declaration, or why did they have to give? Is there a? It's a suit for injunction only. Yes. So, all that you would be satisfied is that this can't be taken to be a suit for declaration.
Yes, Your Lordship.
All that.
Because his prayer are very specific, Your Lordship. May kindly see page number 39.
Your appellant is held to be the owner.
Your Lordship, may kindly see page number 39, Your Lordship.
But did you file a suit?
No, Your Lordship, I have not yet filed it.
Is held to be the owner. That was a uncalled. I mean, this is not in consonance with the prayer?
Yes, Your Lordship, that's
Where is the prayer in the suit?
39, Your Lordship. May kindly see page number 39.
39.
39. The suit is of the plaintiff recovery of
Can
possession
we
of.
just clarify it by saying that it is to be understood in the context of the prayer in the suit?
But Your Lordship, that this finding
30?
39, Your Lordship.
Prayer just shows the prayer.
Yes, Your Lordship. The suit of the plaintiff recovery of possession of plot bearing number
No, prayer
95
in the
situated at so and so Aurangabad, and for due rent amount of 480 and men's profit per month may be please be decreed with
Which
a
page?
construction.
Which page?
39, 39, Your Lordship.
39 is only says that verification, that's it.
No, above the verification, there is a hence spread that, Your Lordship.
Hence paid is a suit of the plaintiff for recovery of possession.
A plot bearing so and so situated as so and so, and for due rent of amount of rupees 480 and means profit 80 rupees, Your Lordship.
Petitioner submits that the High Court has exceeded its inquiry and returned a finding with respect to ownership of the property when the suit itself was confined to recovery of possession. Issue notice.
Oblige, Your Lordship.
The council is in the other court. I pray for
Second round in SLP. Are how? Nonsense. Huh? Any? After the Supreme Court, he went again.
The council is in the other court, Lordship. I pray for a passover.
Is it not a case for cause? Anyway, Passover.
Lordship,
Operational creditor.
just if I may make my case on law.
Consultation services. Tech.
On law. Dispute, Lordship, is an assertion of a claim and the consequent rejection or repudiation of the claim. This is dispute, settle law. The lacuna in the IBC is that the word dispute is not defined.
Not recovery proceeding.
No, Lordship, it's not. And I have to show something because this will render every contract OTOs. Just 2 minutes. I may, Lordship, make what may Lordship calls a valiant effort. Lordship, dispute itself is not defined in IBC. The test in Mobilox, Saraswati, Lordship has also written that, is twofold. The existence of a pre-existing dispute, and it should not be a moonshine defense. I have a contract between 2020-23. I completely finish it. Not a whisper from their side, never a dispute, no claim. My key personnel, one of the 2 key personnel, leaves me, continues performing the contract as an outside consultant. Bills are there. I have 4 phases. He then subsequently gets involved with a new company giving phase 5 and 6. There is no claim from their side. The first time they raise it is in the reply.
IBC Barak then.
They raise it first time, Lordship. So therefore, Lordship, the dispute can't be after my demand notice in their reply, and the ground can't be frustration of contract for a contract that stands concluded. Section 56 won't come into play. So respectfully, Lordship, if dispute is not defined, if Mobilox is the law, I'm saying it. My colleague, Lordship, saw you take the Bare Act and thought dispute is defined. Lordship, now, therefore, respectfully.
The interpretation is not within but without. If you know the purpose and object of the act.
Yes, Lordship.
These acts are not intended for settlement of disputes like this.
Fair enough, Lordship.
It's basically for restitution of a company. We have
Right, Lordship.
Completely forgotten for what reason this IBC has been brought about.
Respectfully, Lordship, that would become the threshold, unfortunately, in every case.
Corporate personalities. Anyway, Mr.
Lordship.
Not.
Lordship.
Thank you. Dismissed.
I am grateful.
19.
Lordship, at least the cost can be waived.
What cost?
Whatever, Lordship, it's a token amount, but nevertheless.
We'll leave it at. How much is that?
25,000.
That's nothing.
I know it's nothing, Lordship. But all of us are here also
Leave
for
it at
nothing. Only on the question of law. Grateful, Lordship.
Cost coming.
Wait, please, Lord. Lord, the Honorable High Court's order is in 2 parts. One is the jurisdiction, on which I'll show the previous judgment of your Lordship, not in our case. And the other is
That
facts.
matter is pending. Your tenancy proceedings are pending.
Yes, before the LRO. And if they are the prior proceedings, then the full bench in Chunia says that civil court will not interfere.
We know
It has to
that
wait.
These proceedings are, done. But you still have a point there.
Lord, Chunia full
When were they initiated?
Lord, my proceedings, 2001, Lord, your Lordship sees annexure P1, page 51.
Tenancy proceedings pending. Can't grant an interim order, but take notice.
I will take notice.
Take notice.
You're obliged to.
20 is interpretation of baggage rules, my lords. The batch is pending.
Bharti, get those judgments, huh?
My lords, so in fact,
Lots of such.
all matters are now bunched together, my lords. So if this goes to that batch, then everything will get listed. Very great. Very good.
May I please, Lord? Lordship, in this matter, the Honorable High Court has dismissed the writ appeal, whereby we were told to go to DRT, whereas the loan itself is time barred. Loan itself is time barred.
It's not the case.
Pardon me?
Alternative remedy is there.
No, my lord. My lord, the matter is that the loan they are referring to, against which they say there is a security interest. There is neither security interest created by a valid mortgage.
That's okay.
And second, first thing, the loan itself is time barred. This honorable court in the matter of Jignesh.
All the more reason. All the more reason that you go and mention that. Why are you unnecessarily availing these remedies which
The problem nowadays, my lord, with
they
the
have given you that freedom? Go avail that remedy. Dismissed.
my lord, my humble submission would be, my lord, that the problem is that there is no DRT working in Jabalpur properly. The DRT is working from the members are working from other side, and matters are not being taken up. And that is the reason one of the partners had preferred a petition before the DRT, and it is not being heard.
That's unfortunate.
My humble, if
Can't be done.
may please then, my lord, I may be permitted to move to the DRT, referring all this ground I have taken in this petition.
Take.
Kindly,
Already that permission
kindly
is
grant that
granted.
liberty, my lord, please.
That granted.
Because the
Please
time
obey.
will be a factor also.
While we are not inclined to interfere with the order, the petitioner is entitled to avail the alternative remedy available under the statute. Next.
Obliged, my lord.
My lordships. My lordship, the
Just
case in brief is the petitioner society was
You
granted.
can file an SLP against this order.
My lordship, actually the case
This
was,
order, how can you file an SLP?
my lordship, it's a continuous course of action. If you may see page number
Nothing. Not
P11, my
It's
lordship.
only for fixing a date, so
My
go there,
lordship,
go
to
to,
expedite the rule is issued in this
don't
case, my
come
lord.
against such orders, please.
And the case is admitted.
Next, item 23.
So my lordship may permit to withdraw the current application.
Dismissed as withdrawn.
Please, my lord, in this matter, my lord, the sole ground on which the impugned order has been passed and a well-reasoned order.
Correct. Notice.
My lord, I'm requesting for stay. Highly obliged, my lord.
Important judgment here. Galat hai.
May it please, my lords. Lords.
He's saying that 37 is allowed on the ground that limited work of commercial. What? Commercial court. It is non-commercial court.
स्टे दे दिया VIPL में
It's not
नोटिस इशू कर दिया
by a court which had no jurisdiction. Statutory bar. There's no bar.
But this is an unregistered agreement, my lords. Lords, we produce it as a matter of evidence, my lords. The High Trial Court allowed it, saying A. it's not
Evidence is all right, but specific performance it's permissible.
Specific performance is clearly permissible, my lords. Even for unregistered agreement, A under section 49, I can show it for collateral purposes, to show my possession. Number 3.
You're right.
Number 3, my lords.
Notice.
Yes, my lords. Lords, may I request for stay because the trial is going day to day, my lords. Yes, my lords. Lords, if at all this entire thing is, Lords, Lord, then my defense goes.
We'll do it. You issue notice, list after 3 weeks. We'll give an early date. That's the in addition. Serve on them and come back.
Lords, may just say notice on the interim relief, my lord?
Yes, yes, notice on it.
Very well.
Concurrent, huh?
No, the High Court completely ignores.
35. No, 25. No, 25.
Yes.
This all happened during the COVID period.
Telling.
This all happened, my lord, during the COVID. And it is, if your lordship don't mind, my lord, may I pass on what your lordship said in this case, in that COVID matter on a suo motu writ petition, lordship extended the time, statutory time which was provided. Just a moment, I'm sorry.
5 years have passed by, Mr. Malhotra.
I'm sorry, my lord. Yes.
The compromise on 15th of December 2020, right?
Exactly. It was heard number of times. In fact, at the threshold, I asked my friend as to why it has taken so long. That the matter was being heard regularly, and ultimately, suddenly this order has come up, my lord, that no, I have failed to explain. The court ignored this court's judgment, my lord, in COVID case.
What are you saying?
I am ready to pay. So far as time is concerned, as
The High Court,
it's sought,
the
my lord,
order
so
of
much time.
Order of compromise at your
Correct.
instance is December
Not disputed.
2020. December 2020.
During the COVID. It was between the
And you
interval between the two waves.
IA filed on April 21.
Correct.
Correct. And anyway, COVID was granted to you.
No.
Right. And then you filed another IA for further extension.
Lordship may ignore that for a moment. The Lordship may ignore that because that has been dismissed along with this. Not much of emphasis on the second application. So far as the first application is concerned, my submission is it was heard in 22, it was heard in 23, 24, 25, and finally it was dismissed without saying any reason. What has been done? Whatever has been transpired in the agreement, whatever has been said in the agreement.
Mr. You have, it appears to us prima facie subject, of course, to hearing you that you have missed the bus.
Sure.
You have missed the bus. That's what.
I'm sorry, my lord.
You have missed the bus.
Me, no. I came in time.
Gaadi chut gayi.
I came in time. Your lordship will kindly appreciate. I came in time. The court heard me on number of occasions on this aspect. And then suddenly, abruptly, the court dismisses my application without assigning any reason, saying that I have not explained. And this is what you're...
Dismissed.
No, my lord will kindly appreciate. I have
not. If you are a owner of the property wrongly taken away, you are sued for specific performance anyway.
The specific performance, what I agreed, your lordship will see
26.
what has happened. The time which was agreed between the parties, that was during the COVID, it was never expected as at that time at the, that there will be no second wave. That's why he said within 4 months I'll do it. But the second wave also came. He couldn't do it.
All right, Mr. Dingra.
And your lord, and this court, my lord,
You are not
considering.
inclined, Mr. Dingra. Dismiss.
No, my lord, it will be too harsh for me.
Can't
Lordship will kindly
Doesn't
consider.
matter, it's not harsh. You are not the owner. You are a purchaser.
No, indeed it will be harsh. I have already paid amount. I am ready to pay the interest what was agreed upon.
For recovery. Thank you. Dismissed.
No, your lordship, the court, my lord, at least this judgment of the court should have been accepted. Should have been looked into. The court says that it has not been. I have no reason has been explained. The reason is the COVID-19.
You are not inclined, Mr. Dingra. Leave it at that. Next.
May I please, your lordship? Look, the similar matter is coming up on 20th of March, my lords.
Post. उसके साथ लगा देना.
हाँ, दस्ती. But dusty may be given, my lords, because the matter is coming deeply.
This is an agreement to sell, my lord. This is a registered document, my lord. It's an undisputedly registered document. Full amount of consideration paid, my lord.
41 lakhs.
In the
Out of
first.
90.
In the first. And then there are two other registered documents, my lord. The GP and the declaration, in which the rest of the balance sale consideration also paid. Undisputed, no problem there. But my lord, the section 43 in Gujarat, as lordships are aware, my lord, that without there being a sanction of the collector, the sale cannot happen you need to have a prior sanction, then the sale. But an agreement which recognizes this aspect, whether that is also hit by section 43, lordships are already considered in Bharat Bhai Millards, page 541.
That's pending. Specific performance, what is it?
Specific performance, Millards. Millards, all those Millards on interpretation of section 43.
Similar matter pending.
Lordships have granted status quo in those matters and considering the interpretation of section 43.
Those were in a different context anyway, issue notice. You are not pass.
Well, otherwise, Millards, my sale consideration was used.
Notice post along with that.
Millards, can I pray for status quo in the meanwhile, Millards?
No.
Otherwise, Millards, the creation, Millards, then
Concurrent, both the courts, let them come.
Millards, issue notice on the interim relief and tag with Millards.
Yes.
Batch. So grateful.
Your Lordship, a letter has been circulated paying for 2 weeks' time.
All right. Settlement.
Yes, my lord.
Yes, Your
The
Lordship.
negotiations are going on.
It's going on.
Of the statement that submission that negotiations for settlement are going on, adjourned by
2 weeks.
2 months.
2 weeks' time.
2 weeks is enough.
Yes, let it be.
List after 4 weeks.
Much obliged.
Please, my lord. They had to revert on how they'll secure us fully. Your lordships hadn't
Right
issued
on
notice.
fact.
I love the fact that my learned friend loves to start even when it's not his petition, but that's
Just
fine.
indicate, my lord, not a big deal.
It's okay. I mean, if he has a point to argue, he can argue because as your lordships recollects, when Mr. C.U. Singh had appeared, everybody's on the page that yes, there is a legal question to be decided here. But because your lordships came with a practical solution, and I'll tell your lordships, we have a practical solution. Can I just hand over some photographs?
No, not all that. You what?
No, there is a
alternative you're going to give.
Correct. So I'll tell your lordships, there is
judgment is correct. There's nothing wrong.
No, the impugned judgment, Milords, for certain.
Right.
Milords, can I just hand this?
Sundaram also is there.
Can I just, Milords, hand?
No, what is we are saying, instead of getting into this controversy,
yes,
you give to them some alternative acceptable property matter ends there.
That's precisely the point, Milords. So therefore, Milords, can I just make 2 submissions? Milords, Sundaram is very clear, you can't go to the seat court. The High Court misinterprets it and says, sorry, you can even go to the seat court. Our simple case.
We'll hear you after you.
No,
This is the point for which we adjourn.
Yes. So now can I give you a lordship?
Don't divert.
Correct. So can I give
Tell
you
us what is it that you are offering?
Yes. So now, Milords, there is a property. Please have a look at annexure P2. And I've got photo.
Why are you telling us, man? If it is acceptable, then matter ends there.
Can I just explain, Milords? Please have a look at annexure P2. This is a property, Milords, which is in Thane, which stands attached as of today. Now, the receiver has to come and take possession of this property.
Give a copy of that to them.
This
If
photograph.
they are acceptable, then there is no issue. We'll dispose of on that basis. Just have a look at it.
Because that 4 crore property, same one.
Now, correct. It is the same one, but today is not valid.
Title now.
There is
different title on this.
there is
One
no
person-
dispute.
When the person went to execute, the one lady came, she said this property doesn't belong to.
So there is controversy about that.
Milords, this property stands attached. That's the first point. The second point, Milords,
Interfere karna hai.
Milords, the second point is this. When they filed their execution application, your lordships may see this order. They went to the prothonory and said, please appoint a receiver. I'll take your lordships to that order. Receiver goes to take possession. There is some issue as far as demarcation is concerned. Your lordships may pass an order, Milords, that today the receiver should be entitled to take possession
The
of
case for us, see, if that kind of a controversy,
Milords, but
we
the
have to
rest of
resolve, we will rather not exercise our discretion and then.
But
close
please
it.
appreciate this.
We're trying to help you out if
Correct.
you can do something.
Now, but Milords, where should the execution proceedings go finally?
We'll decide, Mr.
No, Milords, but how do they go to Bombay?
How do we?
On what basis, Milords, when there is not a single property in Bombay? Milords, please have a look at the list of properties. P4. So the one property that is attached, I am, Milords, willing to concede.
Wherever.
Milords, I am, Milords, willing to concede
Resolving
that the one property that, Milords, I am willing to.
No, the one which we will.
Milords, can I just make, as far as, Milords, this property is concerned, I am willing to concede that let the receiver take possession. I have no difficulty with that. But Milords, as far as the rest of the properties is concerned, Milords, it has to be a district court in Thane, which has to exercise jurisdiction. How can the Bombay High Court do it? Because that's contrary to Sundaram. But it's contrary to the CPC.
It's not contrary to Sundaram.
But what does Sundaram say? Sundaram says that once an arbitral award has been passed, insofar as execution is concerned, today please have a look at paragraph 39 of Sundaram. Very clear. It is not going to be a decree of the court of the seat because it's agnostic to that principle. So now you must go where the properties are situated. Now, if the properties are situated in Thane,
Plus, Sundaram proceeds with the completely incorrect reading.
We know that.
if the
Leave it at that.
but if the properties are situated,
You know that. Leave it
but
at
I'll
that.
just
Dismiss.
Grateful.
Deny.
Both their selfish.
there is
Both the selfies.
In item 57, there is a different question.
What's the question in that? What's the question? Tell us.
Lord, item 57, the question is, my lords, that the award is only qua the HUF, my lords. The respondent number 2 in the arbitration proceeding was the Karta. Against the Karta, there is no direction in the award insofar as the compensation is concerned. my lords.
You are not part of the HUF.
Lords, I am part of the HUF. My
He's
lords.
a Karta also.
My lords, this
Don't interrupt.
this aspect was not gone into by the arbitral tribunal. So the direction says only the respondent number
That
1.
becomes a bit technical. No? These are all becomes technical.
Can I take your lordships to Sundaram? Because I think it's an absolute misreading of Sundaram, my lord.
We'll see later.
No, but
Not-
then your lordships may issue notice in the matter.
Not
Because,
necessary.
I'll tell your lordships why, how does the Bombay High Court go and execute an order, when it's outside?
It's possible.
Under which?
It's nothing.
There is no provision. Under the CPC, you have to transfer the decree.
The decree can be transferred.
Which is precisely the point.
In addition to the state court, the
Just,
yes.
my lord, just Aradhe's make. Yes.
So decree can be transferred at the subsequent stage.
Well,
You
that's
cannot at the mere filing of the execution proceeding, you cannot raise that objection.
Well,
You are entitled to take an objection that they do not have you do not have any properties inside the jurisdiction of Bombay court.
Because I'm so
Based
deep.
upon that,
At that stage, it can be sent.
executing court to take an action for.
That's all I want. That is all I want. My objection to the filing of the execution proceeding was.
The executing court will do.
But that's
at
precise.
the appropriate time.
That's all I want. I don't want anything more. I went to the executing court saying the list of properties which they've referred to are all in Thane. Please transfer this to Thane. I'm not asking for a dismissal. Your lordship's transfers it. Your lordship's transfers it now.
Your objection precisely was that the execution can't be filed at
Correct.
Bombay.
I am making a statement.
It is one thing to say
I am making
not maintainable. Another thing to say to transfer it to
then your lordships may record my statement that I will. At the end of the day, that's all we want.
That's what
Let it
exactly
be.
the court has held also.
The court hasn't.
Yeah.
The court
They
now
have
says
said at the relevant time for the purpose of getting it executed, it will transfer it. But so far as your present argument is concerned, virtually it is in the sense that it is not even maintainable. We won't even entertain it.
The court is passing orders with respect to these properties which are in Thane. That's my concern. That's the whole reason why I've come up, before your lordship.
Not even disclose a list of properties, my lord.
All the properties.
He's not even disclosed a list of all his properties.
All right.
Your lordship, then, can I just make one respectful?
Dismissed.
Lords,
Both of them. Dismissed.
Very well.
Next.
Yes, Michelle.
Please, your lordship.
Grateful, my lords.
Being granted an order of status quo, your lordship. The counter has been filed. There's no averments to the effect that they've taken possession of the property, your lordship.
What happened?
My eviction notice was issued to me, your lordship. I filed a writ petition in which an order of status quo is there, your lordship. On 16/12/2025, a counter is filed in which there's no averment that they've taken possession, your lordship. The matter is listed on 18th, your lordship.
Is this a bit high-handed?
On 18th, the matter is listed, your lordship. The status quo order is vacated, your lordship.
Position taken.
On the statement without any pleading, the counter affidavit, your lordship. The counter affidavit is very silent. They don't state that they have taken possession. In fact, 2 orders earlier passed says that any order passed which is affecting my rights.
But for how long it's going on, is it 2018 onwards?
Yes, your lordship. Because
show cause notice after show cause notice.
Yes, your lordship. Because what happens is, your lordship, I have a patta in my favor, your lordship. The report of the revenue authorities is in my favor, your lordship. They accept that. They don't challenge it, your lordship. When I come to the court says that let an inquiry be conducted, your lordship. Because my only problem.
Now that your possession is taken, right?
No, your lordship. It's still possession with me, your lordship. Because what has happened on
the whole finding is that
no,
the petition is vacated. It's vacated for the reason. Just see what it says. Learned additional advocate general appearing for RS would submit that the forest department has already taken possession of the land.
Yes, Your Lordship. On 16th, this is on 18th, Your Lordship. On 16th, they file a counter. There's no whisper regarding the possession, Your Lordship. The statement across the bar, Your Lordship, which is contrary to the record, Your Lordship.
Anyway, you matter, no? Where do we get into this? I mean, this, whether possession taken, not taken.
Because there's an order directing me to eviction notices issued to me, Your Lordship. I challenge that there's an order of status quo, Your Lordship. On 16th, they file a counter. No whisper about the taking of possession, Your Lordship.
Land, no?
On 18th, the status quo order is vacated, Your Lordship. Because
Correctly. Dismissed.
sorry, Your Lordship. Am I permitted to
Correctly.
withdraw, Your Lordship? Am I permitted to withdraw, Your Lordship?
Want to withdraw. Your matter is pending.
Yes, Your Lordship.
Main matter is pending.
May I please?
Yeah, I think that's a better thing to do. Dismissed as withdrawn.
May I please, Your Lordship?
Yeah, there's a small, I think, we lost turn to page 159.
What? No confusion remains now.
No, the confusion is probably how the tribunal is looking at it. If a lordship at page 159 says, whatever we wanted the court by way of a modification has been granted. Then
Whether
in-
7 years, 1/4/2020,
or 25
32, it will expire. That's all, no?
Correct. Therefore, how does the tribunal, I assume for a minute that the court did not probably want to change the date. I assume for a minute. I go on the understanding that the date remained 1/4/2024. But at page 14, what was told before the tribunal calls all the regulatory commission to place their perspectives on this. So, and the Delhi Regulatory Commission placed perspective and says that the effect would be, if the change is not from 24-25, the effect would be.
Why this contest, Mr. Attorney?
Yeah, Lordship, it's like
7
this.
years we have given so much of a leeway for you.
And the only
21, why are you fighting this? Instead of April 31, if we accept you, it will expire in August 32. That's all that will happen.
There is a
Yeah, right?
considerable impact. That's why
Am I
I
right?
think the commission was told, the APTEL was told.
Ah.
One minute. It's easy to play around figures. It's already easy to play around figures because you don't want to discharge their liability. So it's roughly about 10 to 15% impact for a 1 year. 10 to 15% impact.
Even that should not be. We have gone by your rule, that's all. From the date of
But
the
rule is not
not
under question.
under our judgment. Abide by your rules.
No,
Dismiss.
the rule is not under question as to what will be the date from which you would lordship will go into it.
No, Mr. Thank you, Mr.
Very well.
May I please, Your Lordships?
Is there a letter?
Defendant, Your Lordships.
Is there a letter?
I am for petitioner in 32.
The main suits are still pending. The main suit, the two suits which are pending, Your Lordships, it's over an interim order that is there. In fact, what I can beseech Your Lordships is, okay, make the interim orders absolute. Let those suits be decided.
Different.
There's one suit which is filed by him and there's another suit by me pending before the same court.
COVID thing.
Please, Your Lordships. It's a suit for infringement and passing off, Your Lordships. It's for an interim order and it's a case of divergent finding.
Lordship, mine is the application for recall of the order dated order dated for 14/5/2025.
Injunction is concerned. The present injunction, except for a short period in between, August to 20, except for a very short period in between, otherwise the injunction that they have been virtually using, because there is a stay here also.
Please, Your Lordship. And even otherwise, I continue. It's their case that I was not using it. Once I start, why would I not use it, Your Lordship?
Lordship,
today, 8, Your Lordship, 2008. They are in 2013.
Correct. 2008.
As per the requirements of their plaint itself.
Lordship, today my application, Lordship.
Mr.
Pujari,
they have used this trademark from 2008 to 2019, and also from the time we granted an interim order, which is when?
16.
Whatever, from then to the present.
Please, Lordship, 4th April
Right.
2022.
Lordship, today the question is that
And the main suits are still pending before the trial court.
no, that implement of the manufacturer will have to be
We'll dispose
to
of.
recall, Lordship. Recall of
By
that
the
order,
recall, we will
implementing
dismiss your
the
recall.
manufacturer.
We will dismiss your recall. You are Sanjay. You are for the
Defendant, your lordship. Petitioner defendant.
No,
Petitioner
I'm for the plaintiff, Lordship. Yeah, plaintiff,
you know
respondent. No,
Supreme Court.
plaintiff respondent.
House order, no. Granted injunction. Okay.
In Pune suit, that OCS Pharma
The,
And it's an order of reversal.
was not a party to the proceedings, and we have no claim against that party.
the fact
And that party has been implemented.
SLP is against the judgment and order passed by the High Court on 6/2/2022. No. On 22. What is the date? 16/2/2022. Correct? 16/2/2022, granting injunction in favor of the plaintiff. Stop. While issuing notice, this court passed an interim order and also granted a stay on 4/2/2022, and the same is continuing. Stop. It is also not in dispute that the defendant had been using the trademark from 2008 and continued till 2019 when the High Court had granted an interim order. In this view of the matter, we are of the opinion that interests of justice, in view of the above, I suppose, interests of justice will be subserved if we confirm the stay order passed by this court and direct that there shall be status quo as of today, and direct that there shall be status quo as of today, and further direct the trial court to take up and dispose of the suits,
the two suits which are pending.
both suits expeditiously. Full stop.
Lordship, by recall application.
Your application in this view of
my
the matter, the
recall
recall
application
application stands dismissed. That's better, sir, because there's no point, because for such a long time, from 2008 to 2019, he was using it. And during the pendency of the matter before this court also, he was using the trademark.
Lordship,
We
the
have
recall of
directed the suit to be disposed of. with these observations.
Lordship, the party,
Leave
they are
that-
changing the party, Lordship. The
observations.
party defendant will remain the same.
One factual correction, your lordships. In fact, it's a
It is not correct. It is not correction, Lordship. It is not correction.
matters remanded
It is
back.
a deliberate.
Please, Lordship.
But we are not dealing with that. We know
Please, Lord.
Nageshwara's earlier order was remanded. We've seen that.
Please, Lordship.
But then, so far as the present proceedings are concerned,
Your lordship mentioned, let's say, up to 2019, so that's the reason I thought actually. Your lordship mentioned in the order up to 2019, but it is up to 22 is the impugned order. That's factual
he
correction.
said 19 because that's the date of the High Court judgment.
No, your lordship. That's the first. The second order is in 22, your lordship. It was remanded back.
Then it was granted then, no?
As the lordship, please. I thought, let me just.
You're right.
Please,
But High Court had granted them injunction on 16 to 19. That's why
Yes,
we
your
said 19.
Please, lordship. As the lordship, please.
Now,
I extremely sorry, Your Lord McKinley. Accept my apology. Millet's voluminous documents have been given, all original.
The last one notice only issued to the limited question whether Enam register is unauthenticated copy.
But what he was, the whole argument was that it was.
My first and foremost submission is, my lord, I am a temple relying a title on the basis of Enam register.
Anyways, where is the state?
State is a temple along the party, my HRNC department, Tamil Nadu. Tamil Nadu, I am HRNC department appearing for the temple. Well, Enam, I am claiming my right and title over after the minor Enam.
He asked you to bring those documents, no?
Yes, my lord.
Well, all the documents are with me, Your Lord. That's what.
What do you want, Mr.?
All the documents I have, my lord, now. Your Lord, kindly post it Friday, my lord. I'll file it today, my lord.
Or at adjourn by 2.
Or on next Monday also, Your Lord.
Bring them on record.
I will also produce it. I will also. I am having a copy, original copy. My lord, lordship, note, my lord, while filing a trial court record is going on, original record brought to the court and judges verified, and then copy has been.
Enam spare register. Only argument, only reason why we issued notice is His argument was that this is not a genuine document, it's a forged document.
Government record, my
How
lord,
can it
1942.
be?
No,
There is a presumption in it. And that objection is
Obvious-
waived already. The objection is
Obviously,
waived already. They have made
obviously, and moreover, Inam's fair register is not a ordinary document. Anyway, bring them on record
Yes,
next week.
Yes, Polish.
Additional documents may be filed post after 2 weeks. We'll postpone the dismissal for 2 weeks, Mr. Lighter vein, don't worry.
Your Lordship was always very generous.
34.
I appear for this.
There are two relevant dates, my lords. It's page 27.
Cantonment.
Yes, my lords. It was on 15th of November 2010. Also, I address a notice regarding, my lords, the construction that is to be carried out. Now, my lords, as per section 238 of the Cantonment Board Act, my lords, within 1 month of receipt of such notice, my lords, they were required to communicate.
Your interpretation, show how will it become deemed a sanction? It won't. See the section.
Yes.
Subsection 6. You must issue a second notice which you never gave.
My lords, but the fact remains that even my first notice, my lords, I issued the first notice, my lords, in 2010. My lords, till the year 2013. My lords, till 19 June 2000.
Not like that. 15th of November 2011, you filed an application. So within 1 month, they must decide. That is 15th of December 2011. They have not decided. For a deemed clause to come into operation, you must give a second notice. Only then deemed will. You didn't issue that second notice.
Now, in the meantime, on 4th of May 2011, Mulls, they issue a letter which Lordships would find at
Call for fees.
Yes, Mulls.
When did you pay? How does it matter when they call for fees?
Mulls, the point is,
That's even
that
worse.
there was no. Mulls, there was.
That's even worse against you, right?
Mulls, the
What
point.
will we do? We'll dismiss it.
Mulls, there is only one request. The High Court had imposed a cost of 1 lakh rupees. Mulls, if that Lordships may waive off.
While we are not inclined to interfere with the order passed by the High Court, we are of the opinion that imposition of costs quantified at 1 lakh may be expunged from the order, maybe set aside in interest of justice.
I'm great.
Much obliged.
Please allow. We would like to withdraw this, my lord.
Thank you. I listed. Dismissed as withdrawn.
Your Lordship, I have only e-filed the Wakalatnama yesterday in 36. Your Lordship may have it on Friday. I have access to the brief, though I've seen Your Lordship's order.
You issued notice only for mediation.
Only for mediation. Your Lordship may send it to mediation. I haven't seen the brief yet.
Yes, sir. Your Lordship, there's a humble submission. Stays should be extended, sir.
Is there, Your Lordship, then I don't have access to the brief today. I only filed my Wakalat.
We are only, it doesn't matter. We are not disposing of the matter.
Please, Your Lordship.
Pending disposal of the so and so appears on behalf of the respondents. Pending disposal of the specially petition parties, with the consent of the parties, the matter is referred to Supreme Court Mediation Center. Rest of the order is the common order.
Please, Your Lordship.
List after the mediation report is submitted to the court.
Please, Your Lordship.
Highly obliged.
My lord, I was able to persuade them. And I think give me 4 weeks time, we'll come to the settlement. Everything is virtually settled.
Yes, I believe under the aegis of Mr. Tanka, we'll be able to come to some fruitful.
Excellent.
And
we knew that.
And especially I told both the parents, your priority has to be your children.
Excellent.
Whether especially
Very good.
child. And so I think virtually everything is settled.
Very good.
I think the AORs will sit together and draft something. My lord.
Adjourned by
4 weeks. My lord.
4 weeks.
We like to take a quietness to the all proceedings. My lord.
Very nice. Very nice.
Grateful.
Thank you. Thank you. Adjourned by 4 weeks to await settlement between the parties. Next, 38.
Yes, madam.
These are transfer petitions, Your Lordship. The second case is a criminal case where there are my public witnesses. How these witnesses will travel and give evidence
My lord, let me say something, my lord.
stage itself.
His objection is sustained, your objection is rejected.
Yes,
Even before a petitioner starts, what is this?
My lord, one by one
Never do
another.
that.
My lord,
My sin-
Never do that.
Yes, my sincere.
my lord, what happened, my lord? There are two transfer petitions, my lord. Earlier before that, my lord, another transfer petition was filed, my lord. One case has been filed by the husband against me, my lord.
In that matter, my lord.
That is over now.
Yeah, that is over, my lord. This is the my lord.
You are the daughter-in-law, right?
Yes, my lord. My lord,
The
kindly.
TV case filed by the mother-in-law.
Mother-in-law, my lord.
Transferred to Lalitpur in UP.
UP, my lord.
No, transferred to Udaipur.
Udaipur, my lord. My lord, what is happening, my lord? Another
Udaipur is
attempt
already, child is with her.
with me, my lord. Child with me, my lord. May kindly see their relief in the domestic violence case, my lord.
And the second case is filed by
Father-in-law, my lord. Again, they are.
What do you say?
Yes, Your Lordship. So far as the first case is concerned, Your Lordship, that is the DV case filed by the mother-in-law. Now, Your Lordship, she is already having a joint pain problem. I have filed the documents relating to her treatment from a government hospital. And the second case, Your Lordship, is a criminal case. Public witnesses are there. They have given evidence. The court has passed a summoning order after considering everything on record. And how my public witnesses will travel such a long distance, Your Lordship?
We'll transfer it. Child is there. Transfer.
Oblige, my lord.
We'll give you VC facility. Next.
Your Lordship, how my witnesses, that's not the problem, Your Lordship. So far as first case is concerned, in the criminal case, Your Lordship, my witnesses.
DV is hardly a criminal event. Doesn't matter.
Your Lordship, there is a summoning order passed by the court in which my neighbor has already given
What?
Her presence will be required.
39.
Please, my lordship. Because the pleadings are complete, a counter has been filed. Your lordship.
We filed it in the holy break, my lord, so it may not be on record. We filed it. It's a writ petition. They have challenged, my lords. What we say is compliance of your lordship's order. They say that we have not complied with the order.
The last two notifications were first being vague, my lordship. Vague and arbitrary. In our respect.
Same thing. Sundaram ka hai na? Item 30.
38, 39, my lord. This is
Sorry.
Yes, please. Lord, this is exemption of a minor.
Sorry, I picked up a wrong. Hey, yeah, that's right. This is the 32 petition, right?
Yes.
32 petition.
This is exemption of a minor mineral, my lord, completely from the requirement of an EC. The earlier two attempts were quashed by this court, my lords, by the detailed judgment last year in March 2024. Now they have come out with a third attempt to again exempt minor minerals. The earlier notification.
1 minute.
Yes.
How minor minerals are exempted?
My lords, it's not an exemption. It is a separate, my lords, entire procedure that has been laid down. If I can show to your lordships the impugned notification itself, please just look at the notification. Annexure P15, my lords.
It's interesting.
At page 219.
Page?
219, my lords. Annexure P15. Yes, my lords.
Yes, we are there.
So, my lords, kindly permit me to place from the last para at page 219. This notes your lordship's earlier judgment that the petitioner had filed civil appeal titled Noble Paikada. That was an appeal before the Supreme Court on so and so. Central government filed notification so and so, to the effect that exemption provided shall be subject to compliance of standard operating procedures and environmental safeguards. Then your lordships will see the next para over the page. Whereas the Supreme Court, via its judgment of 21st March 24 in appeal so and so, struck down item 6 of appendix 9 to the said notification as amended from time to time on the grounds that term linear projects is not defined and it's very vague, and the process to be adopted for excavation has not been set out. And thus item 6 is a case of completely unguided and blanket exemption, which is per se arbitrary and violative of Article 14 of the Constitution. In order to address all the issues and concerns raised by the Supreme Court, a draft notification for amending the notification was published, wide so and so, inviting objections and suggestions. The next para, whereas the Kerala High Court titled so and so directed the central government to publish Malayalam version of the draft notification, which central government did. So there was a writ to do it in Malayalam. Then please see. Now therefore
this actually amends the original EIA notification, is that?
Yes, this is an exemption carved out with a separate regime. I'll show to your lordships how that regime is there. Please just look at the notification. And in our counter affidavit, we have explained all of this, man. So this is not an exemption. Please see this, Malat.
Shows the relevant portion?
I'm sorry?
Shows the relevant portion? Which is that exemption?
The exemption is the last para of this before the appendix. I will have to read to your lordships A and then the appendix. A and B both, Malats. Somewhere in the center of this page, 220 Malats have. For item 6 and the entries relating thereto, following items and entries shall be substituted, namely extraction or sourcing or borrowing of ordinary earth for linear projects subject to compliance of conditions set out in Appendix 14. And then Appendix 14 is inserted, please see now. Definition of linear projects. For the purpose of item 6 of Appendix 9 of this appendix, linear project means projects of slurry pipelines, oil and gas transportation pipelines, highways, railway lines, which require extraction of or sourcing of borrowing of ordinary earth above the threshold of 20,000 cubic meter and does not require prior environment clearance under this notification. Then please see the environmental safeguards. All linear projects shall follow the standard operating procedures set out in the appendix. Expert appraisal committee shall, while granting prior environment clearance for projects requiring extraction or sourcing or borrowing of ordinary earth.
Vamshdev, who are you appearing for?
Because I'm appearing for the PIL petitioner.
Wow, who is this PIL petitioner?
Because he's the person who had in fact filed the petition earlier.
You remember the one case which we decided where you appeared?
Yes, please.
That related to when Mr. Ranjit Kumar had appeared. What matter was that? That also related.
That was the issue with respect to DSR.
These matters also we gave 2 judgments on this. But this amendment, what is your concern?
The concern is that
you are not appearing for any builder.
No, not at all, Malad. I'm appearing for a PIL petitioner who had in fact approached this court, Malad, on the last occasion also, and your lordships had caused the 2 notifications by a detailed judgment. Now, the reason it was quashed is because it's vague and arbitrary. In my respectful submission, Malad, it's equally vague, arbitrary, and also absurd now. Because if your lordship,
the amendments now.
If your lordship see the definition of linear project, Malad, it says there is no environmental clearance required for those large projects which require a quantity above 20,000. So below 20,000, you require an EC. But if it's a larger project above 20,000, you don't require an EC. Be that as it may, Malad, your lordships in Deepak.
Central government notification.
Yes, this notification, Malad, the impugned one. Please see the definition of linear project that my friend just read to your lordship.
We'll hear it. Counter. Your counter has come.
Counter has come, Malad.
Filed, it's not on record so far, filed in Holy Brief.
It's a very short
counter
issue.
be brought on.
The only issue is, Malad, mining will go on. Malad, environmental damage will happen. So I'm just requesting any NMD shortest possible date.
Linear projects, Malad, who require to dig and who require to fill it up again. Those are the only linear projects that have been exempted. And please see what is the in appendix 14.
Above 20,000.
See
above
from
20.
where, from how it is to be put back. Everything has been detailed here. So this is a complete regime that has been set up in compliance with your lordship's directions. But I'll show, Malad, when your lordships take it.
The requirement of an EC for a minor mineral, your lordships have consistently and in Deepak Kumar.
Correct.
It cannot be.
Let the counter affidavit on behalf of the union be brought on record. List after 3 weeks. On a Tuesday, Benagana.
Grateful, Malad.
Much obliged.
OTM seeing a Passover.
Sorry?
Passover.
Passover. Mr.
The allegation is against you. No. Allegation is against you that you are not sharing.
No, we have shared, but yes, we have shared. That's what we have said in our counter. But it's a dismissal of our SLP. That cannot amount to contempt. That is the first aspect. Our SLP dismiss, he files a contempt here. There's one technical.
No, in the sense that there is an observation there that you will do it within a period. This is
and we are
happening so often in contempt jurisdiction. Invariably, or small observations, they'll come in contempt. It never used to happen like this.
Not.
And at a time when you pass such orders, it seems very innocuous.
Yes.
But then suddenly you will find a contempt against that order. Actually, you go to the High Court. Why should we entertain this?
Kindly pass it over, then arguing counsel will.
Who is appearing?
Harris Biran.
Go to the High Court, I say. Why should we entertain? I mean, look at the Supreme Court's order. Just look at the Supreme Court's order. What does it
period
say?
of 6 months to conduct this.
Then how can that be?
That has not
It's
been.
not substantive order is not by us. Correct. You should go to the court which passed the substantive order. We use only an extension of time.
May kindly pass it over, then we will argue it.
So tell him that we are going to.
Yes.
You will either withdraw and then go to the High Court. We will give you that permission. Next.
Notice was issued on 1 and 2.
But notice was issued on 23rd September 22. If my lord may just have that order for a moment. What it says is, there was an undertaking given by them before the Honorable High Court. That nobody else will be appointed. If only my services are not required, then I will be relieved. Now, what they do is on a yearly basis,
But you are
relieve me
reinstated now.
for 2 months and then they reinstate. Now they've again removed me.
What right?
So there are some petitioners who have
You have to
been
challenge
removed.
those
The others,
orders.
Well, they have already done that.
Become so often.
well, what I'm
Challenge
saying is,
those orders. They
They
are
have
contempt
the
orders.
matters before the Education Tribunal on the aspect of salary. The Education Tribunal cannot go into all the other aspects with respect to regularization.
But
Why
how
is the college undertaking these aspects? Why is the college not
You are in
regularizing these
contempt
professors?
now.
Lord, what I'm saying is that on every
You
juncture
filed
they
SLP
relieve
against
me.
which order?
Lord, may see the order.
You have filed SLP against which order?
Lord, this is an order of 21st July 22. If my
Where the High Court says that there is no contempt.
Yes, my lord. What they're saying is there's no contempt.
File a substantial petitions
That's right.
against their removal. Withdraw this.
Lord, may give me that. Because what has happened is, my lord, what I...
Well, we are
I may
not
only
inclined to entertain the specially petition against the order passed by the High Court dismissing the content petition. The petitioner is at liberty to... you have been reinstated and removed, is it?
There are some petitioners who have still been
Liberty-
removed. They have
liberty
not
to-
been reinstated.
We'll just keep it open-ended.
Yes,
Adopt such remedies
Yes, my lord.
as may be permissible in law. With this observation, we don't know because there are multiple. That's
Yes.
why we are keeping it
That's
broad.
Some have resigned as well. Some
Just
gave up.
keeping it broad.
What they state before this honorable court is
As
because...
may be available in law as regards substantive orders passed against them.
These petitioners have in fact been serving in this college for last
Go
20
immediately
years.
file a writ and ask for reinstatement at least. They have worked for quite a long time.
Yes. Grateful.
Problem is unnecessary pursuit in contempt.
Grateful.
Item 42.
Please go on. Lord, last time your lordship did hear me briefly. Mrs. Nand was not here, therefore it was adjourned. This is that matter, my lord, where land has been acquired, vested in the government, award pronounced, but compensation is not being paid by the National Highway Authority of India on the premise that we have not taken possession for the last 8 years.
Why are you not paying compensation?
Let's let's kindly see the High Court order itself, my lords. It says possession not taken.
That
The
High
district-
Court order, your lordship has already...
For a moment, because there are two things.
We asked her.
Because the district magistrate has given an affidavit which has been accepted by the High Court.
Possession is
We
according
have
to you, not
taken-
with you.
According to the
Have you
court.
acquired or not?
We have acquired, but the proceedings for compensation under 3D.
Have you acquired or not?
Under 3D, we have taken.
Then if you have taken, if the acquisition is done, they will be able to.
Possession, just a minute. Possession has not been taken, my lord. That is the.
Then you drop acquisition.
No, my lord,
What kind of a
we-
joke is this?
we-
You acquire somebody's
we are
land, you
fighting
don't pay
for a high-
compensation.
my lord, there is section 37 petitions are pending before the Allahabad High Court.
What
They are-
for?
But they are fighting for compensation, for escalated compensation, my lord.
So therefore, existing compensation you won't pay.
My lord,
What kind of a?
My lord,
my lord,
we have not filed anything.
my lord, I'm sorry, we have filed.
Sorry.
We have challenged, my lord, the acquisition compensation.
You pay the compensation within 3 months from today.
We have deposited, that is before.
Let them withdraw.
My lord, then let them withdraw subject to security.
आपको क्या चाहिए? What do you want today?
Lord, we want the compensation. The compensation was
My lord,
paid.
we've already deposited before this
No,
honorable court.
that's also, may I, my lord, correct my learned friend. May I just correct
Because my
my
lord,
friend?
just Oka's order, we've deposited, then for some reason, my lord.
What's the problem? And what do you want today?
We want the compensation, my lord. This
To
compensation.
be paid. What is deposited should be released to you.
Yes, my lord.
Plus, it's simple. I say, what is why you
That's what I only said that.
The amount deposited must be withdrawn. How much is the money deposited?
Right now it's 69 lakhs.
69 lakhs, my lord.
How much have you ever been paid?
We've been paid nothing.
So we will ask that.
This is also
The
one
amount may be
tenth.
withdrawn. Yes.
Plus subject to security, my lord.
What
This is
security? His own land.
We've challenged the. my lord.
Lord, just a
Just one second.
1 minute.
Because
Lord,
there
there's
is
one small.
only one difficulty, my lords, in that process.
1 minute, 1 minute, 1 minute, 1 minute. We will permit you to
Please.
withdraw the money,
Please.
not entirety of it. You have asked for enhancement also?
No. This is my lord, the collector's award.
Collectors.
I'm sorry, equal to that.
You
I have
could-
not asked for 34.
They have not even gone for arbitration.
Arbitration, they went.
It's arbitration.
34 they went dismissed, 37 pending. We have not asked for more. Our
You should
total
release the
amount-
money.
Well, what I'm saying is, well, there's two aspects, Your Lordship. It is one more complication.
Lord, may I just...
There are 11 landowners before Your Lordship.
One minute, we come back to you.
The facts. The total amount is 7 crore something. As an interim measure, this 69 lakh was asked to be paid to us, subject to their eventually deciding in how much time will they take possession and pay the entire amount. Lordship may see the first order. May I just point out to Your Lordship the first order, Mala?
See, this court, apna order. Oka ka order, hai na?
Yes, right.
Lord, 16th of February 24.
10th May is the direction to
Please, Lord.
deposit the amount.
And actually, the idea was in the NHI, there are
You will
lots
just
of-
say that the amount should be
the entire amount which has been allotted to us.
to be subject to the outcome of the appeal.
Yes.
Okay.
Revision, Mala.
Okay.
It will be 37.
We will say that, yeah, now you tell us.
Yes, plus there's only one small difficulty. Otherwise, not this part that Your Lordship is saying.
Amount deposited is
Not
one
on that.
part.
Some other Lordship. Let me mention to Your Lordship. Because there are 11 petitioners before Your Lordship today. And there are, my lords, the total land area is more, my lords. There are more landowners. So, my lords, they who are not before Your Lordship. So, my lords, the amounts that they are saying is not their amount, my lords. It is towards other landowners also.
Say that the trial court will see whoever is there.
Kala, my lords. Very well.
Apportionment.
No difficult. No difficult.
My learned friend is...
This point number
Sorry, I
5,
have to-
Kala, my lords,
I have
the
to
appropriate
keep on
authority.
correcting her. Your Lordship directed that one petitioner be nominated to receive the entire amount.
Whatever it is.
We received it and gave it and returned it also.
So, this problem of disbursement, we can't afford that, my lords.
Was there a direction to that effect?
Yes, my lord. It is there in this.
But
that direction shows that.
Yes, my lord. I'll just point that out to you.
there was a direction. I'll also.
We'll have a look.
That is what they. The problem is, this is what when the briefing is. My Lordship may just have this order of 10th of May, 24. The last para but one.
Just hand over.
Petitioner one who received the amount for himself and other 10 petitioners. And then I gave it to them and I filed this thing at giving to those people. Then I returned it also. It's not, they are just, it's just red herrings, not just to.
It's okay. They are entitled to be careful about. If
I'm
you end
not
up,
saying.
they have a problem. Who is going to answer? You won't be there.
The court wanted to make
Because
it.
the chart is
10th
here.
February.
Yes, my lord. And then I deposited it again.
10th February 24.
Immediately.
Let's just see the chart for a moment. I've handed over after Your Lordship sees the order.
There is a belated compliance report. 69 lakhs has been now transferred to the bank account of the petitioner number 1, who's received the amount for himself and on behalf of so and so.
Yes.
Anyway,
And I dispersed it to them.
Because they wrongfully disbursed. That's my problem. I'll show the chart, my lords, what happened, my lords. Kindly see the chart for a moment, my lords.
Lord, this is a red herring.
It's not a red herring, my lords.
Absolutely.
Somebody else's money, I can't, my lords, do this also. I'm an authority.
Please, yeah, quiet. Please, quiet. Please. They can give it to anybody they feel like. If they want, he's the owner, they can give it to him. My lord, this is the amount.
My lords, the
especially petition is against the. There's only one matter, right?
Yes.
Yes, my lord.
One matter.
Only one matter.
11 petitioners.
And there are several others, my lords. They are only owners of 977
We
square
are only
meters.
our land, please.
And then, my lords, beyond
We'll
that.
all wait for some time.
I'm sorry.
SLP against so and so.
Can your lordship just see
Against
the
that.
chart for a moment?
Award award under the NHA Act under section 3G in brackets 1 was passed on 15th February 2018, granting a total amount of rupees 2.69 crores. Instead of questioning the said order, NHAI filed an application under section 3G in brackets 5 for redetermination of the award before the arbitrator. The arbitrator, by his order dated 9/9/2021, dismissed the appeal under section 3G in brackets 5 and affirmed the award dated 15/2/2018. Then what did you do? Then you filed an.
We filed 34, my lords.
No, against the said order, NHAI filed an application under section 33(1).
Finally,
33, that's the correction of the.
Yes,
not
that's
bothered
correct.
about that.
That's why I came to the substantive.
Okay, that's not. Against, as I go, against the said order, the section 34 application came to be filed. Isn't it 34 application, no?
Yes, my lords, it is.
That's been dismissed.
And that was dismissed when?
That's during pendency. On 14th of August by the district judge.
Which came to be dismissed on 14th of August
4.
Application.
2024.
Now section 37 is pending, my lord.
And no stay.
That is, in the meanwhile, they came to the Supreme Court.
Yes, my lord. And section 37, my lord, is not being heard for
said
2
order,
years.
section 37 application is filed, which is said to be pending consideration.
Yes, my lord. Not being heard, my lord.
In the meanwhile, the petitioners are before this court against the order passed by the High Court in the writ petition under Article 226 of the Constitution, seeking disbursement of the amount. By the order impugned before us, the High Court dismissed the writ petition, full stop. Paragraph pending disposal of the specially petition. This court, by its order dated, initial order was when?
16th of February, my lord.
16th of
February 24.
16th of
it's order dated 16th February.
7th of March, my lord, if your lordship will take it.
16th of February, the first order.
Is the first. 7th of March is the operative, my lord.
7th March 2020?
24, my lord.
No, before that, this court by its order dated 16th February 2024.
Yes. First is 16th.
Directed as under Court Karlena. Thereafter, on 7th of March, the court also directed that NHAI shall pay a sum of rupees 69 lakhs to the petitioners, and the petitioners will accept the said amount without prejudice to their rights and contentions. We are informed that the said amount came to be deposited. Now the Learned Council insists that the amount which is recorded by in the order dated 29/4/2024, which is as under the Court Karlena. Petitioner will provide the default bank accounts. Then what else?
10th May, sir.
And on 10th May, the court directed that now been transferred to the bank. The petitioner, okay. Transferred to the bank, by order dated 10/5/2020, this court directed as under stop. In view of the fact that the amount of rupees 69,15,354 has now been transferred to the bank account of the petitioner number 1. This amount has already been received, is what
Yes, my lords, and then it was set back because my lord Justice Karol, my lords, passed another order saying that you have not got possession. So, my lords, before that,
where is that? 1 minute.
Yes,
1 minute.
that order is 2nd of September, my lords, 25.
2nd of September 25, we were asked to deposit it, redeposit it.
Because possession was not taken, my lords.
No, it was not that way.
I'm sorry, my lords.
This same red herring was
deposit.
Lot of red or blue herrings, but that's what it is.
too many red herrings.
So we invested in something.
And my lord, may I just, with your lordship's liberty, may I just point out?
We are anyway not necessary. We are directing the amount to be paid.
Point
Yes,
to your
because
lordship.
only the clarification, but we made a clarification.
7 crores.
Kala, my lords, the competent authority is R5, my lords, in the present petition. That is the competent authority for apportionment, my lords, as the collector is under the RTF Act, my lords, 2013.
They are already passed the order. We will ask them to be.
No, my lords, the problem is there are other landowners. They are only entitled, my lords, against their land.
Subject to 37 and execution.
but
Everything will be subject to 37 and execution.
The question, my lords,
Why everybody talks simultaneously, sir?
Because
We are asking her, no?
Yes.
Can't you wait for a minute before we ask her?
Because
Plus, you made an application also for clarification. This amount is not for the 11 petitioners before your lordship. This amount goes towards other landowners also, which the entire khasa, which is 2,003 square meters. I've given a chart to your lordship.
We will say this amount will be disbursed to the person entitled to as per the orders passed by the executing court.
Well, that's very well, but the
That's all.
That's what
execution is pending.
I just wanted to clarify. This is equal to the award of the collector under the land.
Let's let R5 do it. I'm
sorry, Lord, I shouldn't have. There's no executing court in this. That's the problem here.
Yeah,
that's why they have to file writ petitions.
Because it's a NHAI.
Well, that's section 36 is pending. My learned friend is incorrect.
What is pending?
That will follow the same pattern as this court has said. In view of a court कर लिया ना, ये 2nd of नहीं. However, on 2nd of February, this court passed an order, the following order. The court कर लेना. Forthwith deposit the amount so reduced. The above referred order is passed in view of the fact that in view of the contention of NHI that possession has not been taken, full stop. Having heard the learned counsel of the petitioner and the respondent, we are of the opinion that as acquisition is completed, the petitioners will be entitled to compensation as determined by in the award dated 15/2/2018. In this view of the matter, we direct that the amount so deposited will be released in terms of the directions issued in our order dated. Which is that order?
That order is
that one where they said on behalf of everybody, no? Almost the first of those.
7th of March 24.
Huh?
7th of March 24.
Well, let's let R5 do the disbursement.
March 24.
Because R5 is Kala, which is the competent authority.
7th of March 2024, as extracted here in above. Needless to, we make it clear that the amounts received by the petitioner on behalf of the others will be subject to the final outcome in the section 37 application pending before the court.
With your lordship's permission, submit for lot.
The amount
This is
shall
only
be
part payment. This is only part. This is about 1/10. Lordship will just clarify that.
It's a part payment.
They will part payment. Rest we
First
will.
time when the amount has come, when you mention this amount for the first time, you mention which is a part payment.
I have calculated it and I have it with me.
Part payment.
Let us have liberty to recover the amount in case we succeed.
Obviously, we will not say something which is obvious.
We are not able to recover, that's the problem with NHS having. Everybody runs away,
Right.
Plus only the liberty that we are able to recover. They didn't stipulate it.
A small request, Mullah. For the remaining amount, we will again have to go back to the High Court in a writ petition. So we lordship will just clarify that whoever is disbursing will disburse the entire amount determined by the collector. Otherwise, we'll have to go back again.
We will not say anything. We are not concerned with that.
37
That is
decide that
was prayer in the SLP, my lord. Actually,
kindly pass some orders
Entire
for disposal of 37.
High Court may endeavor to dispose of the section 37 application expeditious.
I'm so grateful because my problem will be sorted out.
Come back again to your lordship.
Don't come.
So grateful, brother.
Lord, then your lordship knows some.
Don't convert this into an execution court, please.
Lord, we can't help it. There is a statutory lacuna here. There is
Call
no
the next
execution of the award.
48. 33.
Actually, in this case, I am a
43.
I am a brief folder of this case. Page number E of SLP. I have calculated the entire amount.
What's the learned thing is, let me just tell you.
And that date in which the NHI said that the March will be full.
All right, we have already court directed deposit. We are not going to. It's all subject to final execution. Next.
My lords, in item 43, as per in compliance of with your my lord's orders, we have written to them on. My lords, I have filed an application also, but that is not on record, so I'm handling it.
We have not received any letters so far. No.
My lords, there is a. We sent it to registered AD. The receipt is also.
What happened?
We have not received any response from them so
I have
far.
not received any letter. If they are filing, we'll appear whenever they want us to appear.
I have served.
My lords had directed on the last occasion that they will inform us with a letter that we have identified a marketable plot and we can go there and identify it once. That was the only purpose of this letter, my lords. I have not received any such letter.
Check that. Check it out. Check it out. We will have it after some time. Adjourn by 4 weeks.
You can check the address if it is, this is.
Can have a copy. Check that up, check it up.
We'll identify the place.
Go identify, check it up. If it is suitable, tell us. 44.
File your place.
Wait, please. Because there is a report they have
Liquor
submitted.
license not renewed.
License is not renewed, Milord. And
Lease is
recently,
expired. You don't.
after that, we have paid the license fees also, because the issue is that the lease continued till 2028. The property was subsequently sold, but there is a clause in the lease deed that even if there is a subsequent
Lease
purchase,
continuing.
lease will continue, my lord. So that is the issue now, my
The
lord.
lease is continuing.
Lease is continuing according to us, my lord. They said that
It's an
lease
after
is
notice matter.
after notice matter.
Lord, my. That
My friend.
ownership has changed, but then the lease is not up. Ownership has changed, but lease continues, right?
No, my lord, what has happened is my learned friend started by saying that, but hesitated in between. My lord, the possession has been taken in execution proceedings. The club has now gone. It's a flat land.
That is during the pendency of the SLP.
This was an
But
excise
there is a
license
different thing.
proceedings.
Still
They were
this one
they transferred the land to
This one
another
is,
club.
this is infructuous now.
No, but the only
In
issue,
view of
my
the
lord,
fact that the possession of the land has already been taken, the present specially petition has become infructuous. Therefore dismissed as infructuous. Not possible, Pulkit.
my lord, there is an adjacent property where we have already applied for the license. So this may not come in between, because, my lord, we have paid the license fees.
This has, we are only saying not that, we are saying. this
Here,
has
my lord,
become-
the issue was of license. So that has to be considered by the authorities, only that.
That will have no bearing on this.
That's
Thank you. Dismissed.
Lordship, in item 45, Lordship had directed the state to file a reply. Lordship, my reply is ready, Lordship. Just give me 2 days time, Lordship. I'll put it on record, Lordship. I was under the weather during the vacation, Lordship. Any date, Lordship.
After 4 weeks.
Meanwhile, we'll file our rejoinder, my lords, so that
After 4
pleadings
weeks
could be complete.
Filing counter in the meanwhile.
Great.
Rejoined.
Great.
Like, Lordship is putting a date on this matter.
They will give automatically. Don't need.
Please, my lords, in item 46, I'm seeking 2 weeks time, my lord. The counter has been filed by lords, but there's some defect, my lords. It has not recorded.
Wanted some pension.
Please, my lord.
Give them pension, poor chaps.
Lordship, I'm for the petitioners.
November 87 to December 2096. It's be reckoned for council, huh?
It's me, my lords.
Lordship, the arguing councillor is facing some family difficulty, so adjourn it for 2 weeks, my lordship.
Okay. So, next week, kal lena. Next Monday. Do it next week. Don't take further adjournments. With come number of two.
Mate, please.
Kaunsa wala 40?
Well, is that item 47?
No, this is the
47.
statutory appeal, consumer appeal.
So may I submit? in
Yes, it's a
item
statutory
47?
appeal.
Yes.
Statutory appeal.
Coming
I
after.
just received a copy of the rejoinder.
Mr. Sari will admit this. We'll admit this appeal.
Only prayer will be. A widow is waiting since 2008. Some month of like July or something may be fixed, because it's a short issue, my lord. Lordship may admit it and hear it in July sometime, my lord. I'm only praying for a date in the.
What is granted in your favor?
That is, my lord, because of the deficiency, though the commission says 10 lakhs is allowable, that is what they said. And then, my lord, they rejected my claim for the policy, towards the policy.
So you got nothing.
Nothing, my lords.
Admitted, appeal admitted, hearing expedited.
No, Lordship may indicate some month, my lord. Otherwise, these matters, yes.
We'll give you.
He's nearing 80.
48.
Very well.
Well, I have also filed an application seeking permission to file additional documents.
I'll take it, and if any reply is more, we'll file it.
Additional documents shall be filed.
I'll see if
I
there
have
are.
already filed. Copy given.
I'll just check whether they were part of the records and file a reply if necessary.
Definitely
Very well.
part of it.
We'll complete pleadings in the meantime.
All right.
Deeply.
Obliged, my lords.
My lords, this is that matter that my lords have been hearing on contempt, where my lords had said that the fact that the d.el.ed has now been, I'm just slightly differently placed, my lords.
We'll hear the main matter.
Yes.
I'm in the main matter as well, but my lords, if I may have a little bit of time after that.
Just see where we stand. We just find out.
Fair enough.
Can I just?
We just find out.
So, my lord, can you just?
So where do we stand?
According to us, we have
created the vacancies and those vacancies have been filled
What
up.
state? Both of you state?
It's for the board. So we have fully complied with. Now they have a problem, Milord, with the cutoff.
Have you got emboldened because of our last statement?
So, my lord, let me just tell your lordship what the position is. When we started this litigation, we were that 2020 to 2022 course people whose course was completed and they said we are not eligible. So the issue was whether we are eligible. Ma'am, I'll need a little space. You can just come after that. Just.
They never.
Absolutely. That's the point.
Introduced now. I think they would have, and the order said we are one with that group, so they could have been.
So, my lord, that the sum and substance.
What do they do?
So the sum and
Your
substance.
consideration has taken place or not?
Yes, sum and substances, our batch has been considered and our batch is now held to be eligible. Now, at the earlier round, they said that vacancies are not matching with the number of people in two ways. One, general reserve category vacancies may be up and down. Total overall number was in excess. And then subject wise, because Bengali, Hindi, etc., that may not match. So they moved an application saying your lordship directs them to directs the government to alter it. Your lordship said nothing doing. We are not doing anything. We will give you 4 weeks. You please do it. Judgment has to be complied with. So now the board then writes to the government that when the board writes to the government, surprisingly, board says there are 1982 people. Now that's the problem, because during the interim proceedings before this court, what was crystallized on our side was 2513. So 500 and odd people have been knocked out. Now, before I proceed further, I must tell your lordship, 1982 today stand appointed. That is one part of the matter. Now just see 2 pages.
1982 was appointed.
Yes, 1982 appointed. Now just see 2 pages, and that is the long and short of my case, nothing beyond that.
No, then if you 1982 are appointed, then who are you appearing for over and above that?
We are the two, we are from 1983 to 2513. We are those 5, because a large chunk has been knocked out.
Knocked out means what, Mr. Patwalia? Knocked out means what?
Knocked out means
they were
today,
not considered for the reason that there are no vacancies or what?
Today what they did, when the selection process started, there was a group of people
selection process.
who had passed out up to 2020. Those group of people, according to them, were admittedly eligible. We were the ones whose eligibility was under a cloud. Total number of posts advertised were 11,000. When our matter came up before your lordship gave us a blanket stay order saying nobody will be appointed. The board then files an application before your lordships, and those selected candidates earlier filed application saying posts are more, candidates are less. So even if their problem is existing before your lordship, why hold up these 8,000, 9,000 people who are admittedly going to be eligible? Your lordship passed a detailed order after a number of other orders leading up to it saying, today you have 11,000 and odd vacancies. You have only 9,000 people who are eligible. They had 11,800. You have only 9,000 and odd who are eligible admittedly. And then even if those 9,000 are appointed, you have 28 more left, 100 more left, and these people are not beyond 2,800. So your lordship passed an order saying those 9,000 eligible to be appointed, all of us to be called for counseling, and a list of eligible candidates be prepared and presented in the court. Now, after that order comes the second order where your lordship notices that out of 9,000, only 8,900 and odd were those people. They have all been appointed, the original people. Your lordship, they also produced data before your lordship saying that out of 2,600 and odd who came, only 2,513 are eligible. So our 2,513 stands crystallized in that order. Then that order remains where it is, and your lordship allows the SL.
As against the 2,513.
1982 appointed. That's
1982 appointed.
Yes. That's the
balance is 531.
That's the problem area for us.
531.
Yes. That's the problem area.
And all of you represent that 531, is it?
No. Now there are many streams running parallel. Now there is a set of
Paul's case we have at that stage itself said no.
Yes. Yes.
My lords, we are not in the 500.
So, my lord, allow me.
They're having fun.
It has to be one by one, my lord. Let me say what I have to say.
So now, Mr. Patwalia.
Yes.
Not only that,
so
1982 engaged you, you would have gone home. But instead, this 531 are also you are appearing for them.
Correct. Now, apart from that, when the main when the main matter was pending, there were two streams of people who were trying to interject. One was people who had passed.
You leave it that.
Just one were people who had passed out of this NIOS. Your lordship said.
Gopals.
Yes, your lordship said applications are not being entertained. One minute. Anyway, so therefore, so NIOS, your lordship sent back to the High Court. They are pending in the High Court. Then there are people with a dual degree. That matter also, your lordship said, we are not entertaining your IAs. You go to the High Court. They are in the High Court. So according to me, the only people whose claims your lordship had considered were people 2,500 of us out of
531.
Out of which 1982. Now, what is their explanation for 1982?
Not 1982. 531.
530. They say that under that interim order, when they appointed those 9,000, those 9,000 original who were without any cloud, your lordship is with me, those 9,000, it so happened that the last candidate out of those 9,000, who was the last qualified person, had X number of marks. Today, they are treating that X as a cutoff and saying that anybody else who is below that X mark, we cannot be appointed.
Although he's eligible and qualified.
So how, from where are they getting this cutoff? But there was no cutoff.
You are not in an appointment stage. You are all at a stage of non-consideration.
Correct.
So now, where is that evolution of your position being at a non-consideration
There is
stage
no cutoff for
cut off
anybody.
a right now that we are not
There
being
is,
appointed?
my lord, there is no cutoff for anybody. Throughout the process, there was never any cutoff.
Or anyway, you are saying that,
I'll tell your lordship, that last
what you are
cutoff,
saying is that there is no ineligibility
Yes.
for excluding you. We'll just start
out of those 9,000, everybody was taken. It so happens that the last person out of those 9,000,
These are school teachers, is it?
they are, my lord, yes, primary school teachers. Assistant teachers, primary. My lord, just see that, my lord, actually,
My lords,
just 1 minute.
There are
My lord,
available vacancies.
Yes.
Will proceed in
My lord,
the December.
my lord,
If you are not eligible. So today an artificial thing is brought in to put a cutoff.
my lord, the strength of what I am saying will not be fully with your lordships unless your lordship reads that order. Just kindly have my affidavit, which I have filed on 9th February, and just see that order. They have themselves stated before your lordships that we are qualified. Yes. Now, please see that order.
1 minute. Show us the impugned order. Our order. What's
Your
the final
lordship
direction?
Yes. Your lordship's order is
Final direction.
Yes. The final direction is at page 152 of the paper.
My paragraph, you tell us.
Paragraph 32.
Apart from our reasoning that the recruitment notification dated 21 is legal and valid, and also we have no hesitation in exercising our power under 142. Okay, in view of the above, we allow the appeal and set aside the judgment and direct the respondent to process recruitment process, which commenced in the notification, must proceed further, and the most must take immediate steps for concluding the recruitment process as expeditiously as possible.
My lords,
First, to examine the legality and validity of the judgment of the bench of the High Court. All
there
applications.
is no arbitrariness. You are on the same.
We have concluded the process and
all applications.
This is a fresh cause of action, not in a content proceeding. We want challenge cutoff date and all that.
531. 531.
Just read that one.
Perhaps by that.
What is being stated is that there was no cutoff. But
Yes.
that whenever there is a vacancy and there is more candidates than the vacancy, there is
But
no
I think
cutoff.
in the
Here there are less candidates.
Vacancies more.
I think they are perhaps justified in saying that in view of the fact, once a consideration takes place,
Yes.
there would not be any ineligible person to that extent. 1 minute, to that extent. So therefore, when there were vacancies and that minimum basic qualification is available, then to create an artificial cutoff and reject somebody is not justified, is what you're saying.
One example, not too complicated.
No, Malad, before my friend starts, I need to read one paragraph because the strength of what I'm saying.
But from our judgment, we cannot.
Just kindly have one paragraph.
The way you are pitching it up, as if, completely, as if it's contempt jurisdiction, you're going to make appointments.
Therefore, my lord, this additional affidavit, please see one paragraph. This additional affidavit I have filed on 9th February.
This is only for the reason that unfortunately in our country, persons who are intended to be teachers should not be waiting in courts like this.
Correct.
But then there must be there is a limit by which a court will take it up in a contempt.
Lord, this is the 28th February 24 order.
If you're talking about it, why?
29th.
Don't take it up in a very adversarial way.
Malord,
My learned friend Miller just now.
There are no, Bobby. There are.
I just want.
If there are vacancies,
No, there are no vacancies.
If there are vacancies,
Malord,
As per their own affidavit.
Your Lordship, just let me say something, please.
Just 1 minute.
No, why you? We are the respondent. He is an IA.
Wait a minute.
Gopal has a completely different case. He has to file.
We are not hearing him.
My lords, is there?
Tell us. We are hearing. We are asking him to say.
Yes, there are 2843 vacancies and only 2109 candidates.
Will you listen to the judge at least? One category, general,
there are no vacancies.
Total number of vacancies. So that this total.
You are reading from the notification.
Yes, under the notification.
Where are you reading from?
Only
one.
What's
no, but give it to us also.
Where does the
you don't want us to see it. Unless you give it to us, we won't be able to show that this is wrong.
I'm just trying to explain these. Yeah.
You asked for vacancies from the board, although.
See, listen.
And we have a few more copies.
The contours of this like that is like this. We are aware that this is in contempt jurisdiction.
Yeah.
And now we try to coax you to do it, but if this needs to be heard, then we will hear all of you then.
Correct.
We'll hear it.
Correct.
If it is. If it's a clever way to get over the order,
yes.
They will have it in their neck.
Extend the cutoff.
We'll ask. Of course, we will ask. Yes, what is your problem? Doesn't matter. Tell us.
At the interim stage, what Mr. Panalia mentioned that 9,000 now who are fully eligible. Just the Tima Kohli's order of January 22 said, out of there, 9,000 fully eligible. The point is, in the letters, saying, what happened here?
How are we expanding this petition? Today, it's only a contempt order.
Additional orders in contempt proceedings by parties for not.
So what?
That's the point.
Oh.
Remain in a contempt proceeding.
Tell us.
Which on 29th January 2024, the interim stage, where the sentence is almost recording their submission. There's which after modification saying you say that please allow the school that we to have here. Where your lordship don't. I think they got the fact that I think 11,558 respondents have found 95 eligible candidates, including the additional 5% candidates. It is deemed appropriate for the respondents to declare to the rider.
So you are part of that, is it? Why is it before us today? You filed a contempt against that. Why? How? We have not even entertained you. We will not permit this now. We are losing. What is this? Each one.
You are not a petitioner.
My lord, he is not a petitioner in the contempt. How can he argue, my lord?
Because we are the contempt.
Please, all of you, there's absolutely no discipline at the bar. Adjourn the case by 4 weeks.
My lords.
Let the petitioner.
We don't like this at all.
Yes.
Not the way to. Adjourn by 4 weeks.
My lords.
We'll see later.
My lord, these IA should be rejected, my lord. They have.
Come back. You will have to talk to yourselves, all of you, how to conduct for us.
Sent to the High Court for a
We will not have after 3 weeks.
So I think think somewhere down my lords will hear the original contempt petition.
Correct.
We will.
Correct. Correct.
Yes.
The IA.
No, the IAs or the MAs can't override the
We'll put a recorder here.
It's not an amendment.
How can he file an MA in a
If you permit us, we will do some other work, please. Can you leave us today?
My lords,
Adjourned by 4 weeks.
my lords, there's a very short.
We are not going to hear you today. Next.
Fair enough, my lords.
49.
This is that case in which your lordship had issued notice, section
What happens
53A of transfer of property vis-a-vis an IBC proceeding, where I have been in possession of the property.
Yeah.
Where I have been in possession, the Dasti was affected. I guess my friend is.
I'm the main contesting respondent, my lords. I have a
For one and
which can be suitable to him also, my lords. After his submission, I can submit.
CIRP started on 13/10/2023.
Yes, your lordship. Now, there are 2-3 dates in which I would like to just enlighten the court. The admitted position is that I have been in possession of the property since 2012.
You filed a suit for injunction.
We filed a suit for an injunction. That suit gave us an injunction. Thereafter, the liquidator filed an appeal before the High Court, a writ petition before the High Court, without taking permission under 33(5) of the IBC. The appeal was dismissed. We filed a review. The review was dismissed. That's how we've come in here. Now, this is that issue in which I highlighted to your lordship, saying that 53A of the Transfer of Property Act gives me protection if there is an agreement, undisputed agreement.
Okay. We should not. It's a recently only we gave you.
You on the last day before vacation. Only thing was that property was also highlighted in the proposed auction on 4th March. So your lordship wanted to call.
Dinesh, we will hear this sometime.
No, but I have a proposal, my lords, which may not be agreed by this proposal. I am for the liquidator. And there was a liquidator representing the company. And there was a CIRP proceedings. There was no claim. And after that, liquidation proceedings went on. And proceedings are going on. Liquidation proceedings are going on. Then the petitioner says that he entered into an agreement to purchase.
What is the proposal?
My lords, my proposal is this. I'll just come into that, give the background facts, and just 1 minute only. The petitioner is a person who entered into an agreement to sell with the company, corporate debtor, in 2011, while the properties are already mortgaged with a financial creditor. So the validity of the agreement also I'm not going into. But already in mortgage. So I'm also not going into that aspect. While the liquidation proceedings are going on, the person who entered into the agreement, he files a suit saying that his employees are staying in one of the properties. So they should not be forcefully evicted. So the remit of the suit is only that the employees, he is admitting my title, he is admitting my...
He is the plaintiff.
He is the plaintiff. So he says his employees, he is running a textile shop, his employees are staying in that particular property. He should not,
he is the purchaser, the original owner filed the suit.
In fact,
no, my lords, not original owner.
No.
Original owner, he
himself filed the suit.
He himself files a suit.
Okay.
The original owner is the proprietor.
Trial court granted an injunction.
Yes, promoter of the company. And trial court
vacates it.
Trial court, he makes an averment before the trial court saying that the liquidator is a real estate agent. So I see a prima facie case. So employees should not be evicted. So that's the only remit of the case. That employees should not be forcefully evicted. He has no problem with my title because he never entered into any claim.
So the suit happened to be filed after CIRP commenced.
After liquidation proceedings are going on, because this agreement to sell is in 2011. And
in any event, CIRP commenced on October 2023.
And
liquidation order came to be passed on December 24.
And he has no claim. No claim before the liquidation, liquidator, no claim during the proceedings of CIRP also. And this suit is filed much after 15 years. So his only limited claim as per the suit prior is that his employee should not be evicted. So my proposal is this only, my lord. Let him take 1 or 2 months, make alternative arrangements for accommodation of his employees. Anyway, the title is
permanent prohibitory injunction.
That's true, my lords. And he made up averment. I can show, my lords. He has portrayed in such a manner that liquidator is a real estate agent. That is his suit. Show me the suit. The Your Lordship, kindly see the prior of the suit, page 59. Page 58 is the averment. Page 58. Para 9.
What is the suit is about?
Suit is saying
What is the
that
basis for the suit?
basis of the suit is that he entered into the agreement to sell with the promoter of the corporate debtor in 2011. 2011.
The mortgage.
Mortgage is in 2007, much before.
In favor of?
In favor of the financial creditor. While the property was in mortgage. Yes, my lord. That your lordship can.
Second life.
Second life is trying to revive, and he also talks about all the NCLT proceedings. The remedy lies before the NCLT.
What did
Lordship, may I just clarify a couple of points? I'll leave it to your lordship after that. The first point, that the suit has been filed by the original is wrong, because page 49, the petitioner here itself has filed the suit. Because lordship, see page 56 PDF.
Wow. At this point of
this
time,
particular corporate
2025 filing a suit for injunction.
No, lordship.
We didn't know that there was a prior mortgage.
No, I'll tell you what is the thing in this, your lordship. It's not a mortgage. The same corporate debtor addresses a letter to me as early as in 2012, saying that, can you pay the debt? He acknowledges that I have an agreement with them.
Half of the facts are not before us.
Yes, your lordship. I was just.
You never told us about.
Of course, I told you, lordship.
What prior to that existing mortgage?
No, lordship. I have an agreement under 53A. That is not disputed. That agreement is not disputed. I have been in occupation for the last 15 years. I won't be entitled to.
Dismissed.
Your lordship, just one. If I just take 1 minute.
We will give you some time for vacating.
Yes, my lord. That's what. If you want to make an alternate.
I've already paid around 1 crore rupees into it.
How much time you will take to vacate? Tell us.
It's only employees, not even families.
How much time?
Bachelors.
Lordship, give me 4 months of time.
Well, we are not inclined.
Or your lordship, one more. May I take one more indulgence in this?
Petitioner shall, subject to the filing of the usual undertaking, vacate the premises on or before 31st of July. We'll give you till August, 31st of August.
Lordship, may I ask for one more indulgence in this?
All right.
Lordship, one more indulgence. I'll just take a minute. What happens is, if I have to enforce my right, I can only go to the NCLT. Now, 53, no, the problem here is, your lordship, I'll tell you what is the legal problem here. 26A says that NCLT has power only under money claim. Now, how do I go for 53A? If your lordship could at least give me a liberty to file an application.
You can't go beyond your prayers in the suits. You can't go beyond the prayers of your suit.
No, we'll leave it at.
Allow me to speak, please.
Nothing more. Thank you. 50. It will be subject to the filing of usual undertaking.
Lord, this case pertains to Bokaro Steel Plant in the state of Jharkhand, my lord. The initial contract which the respondent was executing was
25 November.
Was confined only to this Bokaro Steel Plant, my lord. The suspension order was challenged in the High Court of Calcutta, saying that my office is in Calcutta. Then the show cause notice was also challenged there. And now on page 4, my lord, our tender process has been stayed. Grateful.
Notice stay.
Stay of further proceedings.
Stay of the High Court's order.
Yes, my lord. Yes. My lord, may come down the delay, my lord.
How much is the delay, Bob?
Against the last order is of December 25, my lord. But the two earlier orders where he was said that he may not reply to show cause notice. Now we have challenged all three.
What happened now? We will not. How much is the delay?
636 days.
636 days delay.
No, my lord.
December 2025 is the order.
December 25 is the last order, my lord. And
that is the order we are concerned with.
Yes, my lord.
Where they granted a.
And now we had filed it in March.
We decided
in February end, my lord.
No, where the stay kiya tha na.
Because there are two previous orders also, therefore the delay so much. Otherwise, the order is of December 20.
Today they have. You issued a. When did you issue the latest tender?
4th of November 25.
NIT.
4th November 25, my lord.
What happened to that?
That has been stayed by the Honorable Calcutta High Court.
By the order impugned.
And my lord.
Is that one?
Yes, my lord. That is the one. And we have to
finish. Stay this 24/12/25 only. Will stay. Until further order, the order dated 25/4/2025 shall be stayed.
Grateful, my lord.
You have not issued notice in any of those. Issue notice till the next date of hearing. Order dated 24/12/2025 shall be stayed.
Grateful. They'll serve the purpose because before.
Oh, you were there for the caveat?
No.
It was called out. So we
Grateful, my lord.
T2.
My lord, in 52, I'm requesting for an accommodation. Could it be next Monday, my lord? I'm led by Mr. Amit Sharma, who's the counsel for BCCL. He's in some.
Monday is all right?
Deeply obliged.
This clarification only. बिल्कुल कल के ठीक है
53 may I request for a passover, Lordship.
53
53.
Paso.
Much.
Suit for specific performance, my lords. The High Court has not framed any substantial question of law. It proceeds on the. It also records, my lords. Kindly come to the. I'll take your lordships to the impugned order first.
The fresh matter, right?
Fresh matter.
Tell us.
Tell us.
Yeah, yeah.
Oh. My lords, may kindly come to page 3 of the impugned order. The High Court records my contentions on the substantial question of law. It's admittedly a joint family property, my lords.
He's the owner of the property. No? But then that fact that he knew joint family.
My lords, the plaintiff issued.
That fact is a question of fact which both the courts have said that no member of the joint family has ever objected.
There is
no.
There's also finding, my lords, by the trial court. By the trial court, based on the materials placed only, and then it comes to a conclusion that the oral agreement has not been proved.
All facts.
My lord, it's a substantial question of law because the parties who are necessary parties were the brothers of the deceased.
Findings are that the property is no longer joint. There is already an existing oral partition, and also that no.
It is a false statement made in the agreement, my lord.
How do you get over these three?
It is a false statement. We have taken that contention in the written statement also. I'll take your lordships to the written statement.
What we are asking you is, how will you get over these concurrent findings of fact?
That is the only hurdle, my lord.
Without those, how can you proceed any further?
But he issued notice to the brothers of the deceased. He knew that they were also part of the. They were also made to be made a party. Then we raised that contention in the trial court. He didn't take any necessary steps. Then he.
Thank you. Dismissed. 55.
As for the last election, we filed the affidavit, Milad, and I need to say three things.
Before he starts, let me exercise the petitioner's right for just 1 minute. Your lordships passed an order that day, doing Millad's a justice in terms of moving the goalposts in his favor by shifting 2017 to 19. My lord recollects, 2019 is double the rate that 2017. Now he says, I give 2019 plus 30%.
No, I'm not saying that
That's
at
what
all.
he's saying in the affidavit.
I'm not saying that.
He is.
If you don't mind now, may I just respond, Milad? I need to say three things, Milad, because
This is all in contempt, Mr. Dr. Singhvi. This is, it can't be because of
Milad, I need
order also of this court. Is not an adjudicated order.
Milad, I would point out they have said certain things earlier which were factually wrong. I have filed an affidavit after 35 years.
What is it?
May I just point
Anyway,
out.
what is your affidavit?
Now, number one, Milad. Yes, kindly take page 8 of my affidavit.
Affidavit dena.
This last affidavit, Milad. I have three things, Milad. May I say it orally?
I haven't seen the affidavit yet.
May I state it orally, Milad? Malaj, may I point it orally, Malaj? May I state it orally? What we've said is this. Malaj, we have to determine a rate. We determine a rate on a year-to-year basis. For 2019-20, as per the calculation, the rate is about 1,10,000 per square meter. This is the rate, Malaj. We've said, we put the notification. The rule 8 says commercial plots will be given by auction. And it says that it will be double of residential plus 10% for corner, etc. It comes to 1,10,000. I've said so on affidavit. This is one part. Number two, what is important here is this. The High Court had passed a detailed judgment by which they said, we have to give them a plot in the same scheme. We came to your lordship and we said that there is nothing available in the same scheme. Your lordship said, Justice Nariman's order, that you give them a similar scheme. Number one. Number two, they said, we will give the old rate. Your lordship said, no, market rate from an auction done in the recent past. Now, when this order was passed in December 17, we immediately got moving, Millets. I have put on record the board resolutions, the agenda item, etc. And in the beginning, on February 19th,
your offer
my offer, may just take 2 minutes. It's important, Millets.
My lord,
we offered them, Millets, in February 19 in a similar scheme. They write back saying, no, we don't want this. We want in the same scheme, in spite of your lordship's order, and we want this plot. Now, this particular plot was under litigation at that time.
When it got free of litigation on the 11th, on the 11th of April 25, when we decide their representation, we immediately on 12th April offer it to them. And we tell them that, see, this was the market rate. We are offering you at this rate. Now, they have this particular plot, which was under litigation. That person moved an IA before your lordship. Your lordships, this honorable court, my lord, the Chief Justice's court passed an order, which your lordship will find, at page 57 of my reference.
The date?
This order of your lordships is of 14th of May 25, where your lordship said that, see, you move the appropriate remedy. Now, this person then, gave a representation to us, which we rejected. He has now filed a writ petition in the High Court. So, this particular plot we need to see on affidavit, which we had offered to him on the 12th of April, is today again under litigation by the person who originally had it. Number one. Number two, I have put on record.
That writ petition is by whom?
Is by the person to whom this plot, which they asked.
That's pending.
Which is pending. Number one. Number two.
Are we concerned?
Number two, your lordship's direction is very clear. Give them a plot in a similar scheme, not the same scheme. That is what we challenge. Your lordship allowed that. Now, this plot was in the same scheme. And isn't that what they were? And they said, we don't want a similar scheme. Give this plot, which is the same scheme and is commercial. They had institutional. This person has, then given a representation saying, I will give 10% above the market value. We had offered to them at 1,10,000. I have shown, the past two auctions, the auction rate is 30% on an average above our fixed rate. And the fixed rate we have given is of 2019. Today in 26, the fixed rate is far higher, plus 30% above that.
What is it that you are finally suggesting?
So, we have here, just hand over the affidavit, please, Mr. Court. Now, it is our duty.
What is it that you are?
We are saying there are two options. One is, if your lordship sees page 8, I have quoted the rule, and at page 10, I have mentioned in the past what the auction rate, etc. was, and what the circle rate was. Page 10, if your lordship sees.
Finally,
we have offered, at page 10, 1,10,000 is the rate. 1,10,000 was the rate in 2019-20, which was your lordship's query.
Instead, your offer is now a particular, not a plot, but a amount, is it?
No, we are mentioning that plot, but it is our duty to point out that it is today under litigation again. Because the Honorable High Court.
Nothing, according to you.
No, there is similar plots are available in different schemes. He wants in the same scheme, in spite of your lordship saying, if your lordship will just see your lordship's order at page 19. The High Court order was at 7, just see page 17 first, the High Court direction, and how your lordship change it. Now in contempt, they want to actually violate that order. Please see page 17, the High Court direction, which we challenged.
Therefore, it needs to be.
Just see page 17 first, then their context will be clear. The last line at page 17.
So, now,
today,
this is all.
Now, page 17, the High Court said, last 4 lines, however, in order to avoid further litigation, settle the dispute, we feel it appropriate to issue the direction to the Housing Commissioner to allot an alternate plot of similar nature, commercial nature, in the same scheme to the petitioner. Now, we came here, kindly see your lordship's order, page 19.
Mr. Nidesh Gupta.
Yes, I need to.
Don't go round and round.
No, not at all, we are in your lordship's hand, We will give it to them. Now see your lordship.
Finally, tell us.
Yes, now please see page 19. Your lordships.
As per the court's order,
yes.
What is it that you are now offering?
So, we have 2 options.
Don't say anything. Just show us what is the options.
Now, number 1, in a similar scheme, as directed by your lordship at page 19, we have offered to them which they are rejecting. The direction, please just read the direction first, page 19. In an appeal against this order, I showed that order,
Just follow this.
In an appeal against this order, learned senior counsel for the appellant has argued that there is no alternate plot left in the same scheme.
No, all that is.
But that an alternate plot in a similar scheme.
Having gone through the papers ourselves and having regard to the.
Having regard so-and-so, we are of the view that
should be allotted another plot.
In a similar scheme, not same scheme, provided the market value for the said plot is determined by sale of similar plots. So your lordship said market value. Now, when we offered to them a similar scheme, they said no.
Provided the market value for the said plot is determined by the authority.
By sale of similar plots.
What does that mean?
Similar, the kind that we offer to him, it should be the market value, which is determined by auction.
Market value such a plot is determined by the authority by sale of similar plots.
Plots in auction that have taken place recently.
That what was originally allotted to him.
Yes.
similar kind of a plot which is determinable on the basis of a
Market value now.
sales, market value
Yes.
of sales.
Now, Milad, when we offer to him after this order in February 19, he says, I don't want similar scheme. Give me this plot. Now, just see his letter.
Anyway, your whole thing is you're going around on the basis of the similar.
Now
It's not identical, it's similar.
Now, no, Milad, your lordship said, accepted our appeal to the extent that because of the same scheme, there is no plot. Now, when the litigation ended and a plot came up, we offered. But that plot is again under litigation. We don't have a problem, Milad, we can offer.
What are you now doing?
Now, Milad, there are two options. Either your lordship records that there is litigation, but we are willing to give it to him. And that is the plot he wants. Otherwise, similar scheme we have offered. We have two other plots we can offer. Those also he can come have a look, go and see the plot and see.
All right, we will hear them now.
Now, Milad,
Just tell us.
Milad, this is what happens, and I'm going to choose.
What happens? See, there are three options he's giving.
Your lordship will not straight away come to that. My lord has allowed the respondent to open the whole history. I'll take 5 minutes. Just
of course.
My learned friend was specifically in the presence of each of us told, not once but twice by my Lord Justice Narasimha, to come with an offer and we'll not be hearing arguments. Number two, I am saying with the responsibility, there is some malicious mind working in his organization who has instructed them to harass me with the arguments your lordship have heard. And if your lordship agrees with me, your lordship will issue contempt notice to him. Number three, the 2017 plot was directed at 2017 dates by Supreme Court order by Justice Nariman's bench. Don't open the pages, just note the point.
17, no, we just noting it.
The order of your lordships, and your lordship will issue contempt now in case of
4th December 2017.
This is mischievous to the core, Balas. Just note, Balas, 8th of February 17, the High Court order, impugned in the Supreme Court ultimately, says give alternate plot in the same scheme of a similar nature. Just note, well, this is shocking. Right under your lordship nose in 2 weeks.
All right, the same scheme.
Same scheme.
8 February 17.
Similar, that's it. That was High Court order at page 18 and relevant at 50. Don't go to it, Malad, just go to
That is the one which has led to the impugned order, right?
Yes, that led to the Supreme Court order, not impugned order, Supreme Court order.
No, Supreme Court is 4th December 17.
That's right. So this is the order underlying that Supreme Court order.
Correct.
So I won in the High Court saying same scheme,
so
similar plot. Number two, the Supreme Court affirmed that order at page 24.
Correct.
Relevant at 56.
Allowed. Appeal is
now, I didn't interrupt you, Mr. Gupta. You have argued contrary to my Lord Narasimha's direction. And your officer is trying to mislead the court.
So, should the allotted plot in a similar scheme provided the market value?
Right. Now, why was this similar said? Because they took a plea that there is no alternate plot left in the same scheme.
Today, what is available? We will direct them.
No, just this is important. The order was in the same scheme, give an alternate plot. They made a submission to the Supreme Court. In the same scheme, there is no plot left. So the Supreme Court said, if not left, then quote unquote, if not left, it is argued that there is no alternate plot left. Therefore, give another scheme in the similar of a similar plot.
What does that mean?
Number three.
What does that mean?
No, something more happens after that. Number three. In response to that, they came and offered me a plot 17 kilometers away. This is the word similar they are playing on. Number four, 17 kilometers away. Number four, Justice Nariman's bench was extremely upset and said 17 kilometers away is your definition of similar. Please give the plot. So
where is that order?
Yeah. No, that was orally. The order comes with there. They came back then and said, yes, we have a plot, but it's under litigation. 1 minute. That's stand number 4. All this is before your lordships.
No, when they said that, what did Nariman say?
Then said, this is a false statement. There is no litigation because they have cancelled that man's plot, whom they are now putting against me. Cancelled by Mr. Neeraj Gupta's client. That's stand number 5. Today, after Lordship Supreme Court order,
when they came back and
they said, yes, we
there
agree.
is yet another plot, but it is under litigation.
Then
what do you have to say about
they
that?
They then offered me the correct plot.
Which is
saying, no, they offered me the correct plot, saying we were sorry, though there was no plot available, that plot of the other guy we have cancelled. The other man we have cancelled. That is the correct stand, which they falsified first.
Which is the correct plot? What is the number?
That number, I'll give you. Give the number. So we were okay with the plot. Now the plot.
That is in which sector?
Plot identity is over now. Give the exact address here. So today raising this plot identity is a serious contempt. It's a serious contempt.
Give us that plot.
Now, let's plot. Let it be sure.
11 CP5.
Plot 11 CP plot 11 oblique CP5.
Page 69.
And this argument is not raised.
Which sector is that?
Vikas Nagar.
Vikas Nagar.
This is UP Awas, but it's not Noida. It's UP Awas scheme, Lucknow. We are talking of Lucknow. Now there is no difficulty of identity, matter is over. Then they come with a plea.
So that doesn't matter. So therefore, according to you, this plot should be given to you.
Yeah, it's available. Today, for the first time.
Saying that this is the one
now under litigation.
Kindly let me
But I leave it to your lordship.
No, Manas, kindly let me finish. No, I'm sorry, I'm not finished. I'm not finished, Manas. Your lordship has to be sufficiently shocked. When the matter came to the Supreme Court, this plea about plot identity being different was never taken. And Justice Narasimha's recollections, Aradha's recollections show that. The only issue was rate. On rate, what they did was, and today they are arguing identity of plot, which is why I'm seeking contempt. Your lordship agrees with me. Now, Malas, on the rate, they said the order was 2017. The order said give it 2017 rates. They came and said because your lordship said recent auction, there has been no recent auction. So the seventh stand is we will give to Mr. Singhvi at 2025 rates plus 20% premium ad hoc.
Today.
Now, when it came to your lordship, Justice Aradha's bench, your lordship said, forget all this. We, the bench, will shift the 2017 to my detriment to 2019. That's what my lord said in presence of everybody. 2019 rate is double.
We were just still examining and understanding the matter.
Kindly bear with me.
Against.
Kindly bear with me.
We have not heard the matter at any point.
This is very unfortunate for a public thought. Your lordship shifted 17 rate of 66,000 to 2019, which is 1,11,000.
But then instead of getting into the value of the property.
Just 2 minutes left, 2 minutes. So my lord shifted the goalpost to my detriment by almost double, 66,000 per square meter to 1,10,000 per square meter. Right, Manas? Till now we are okay. Then my lord adjourned it because he sought time that I have to check with my client and give an affidavit. Now he comes today with an affidavit for the first time saying, I am prepared to give 19. That is the rate your lordship put. But add ad hoc 30%.
No, I don't say that.
That he says directly in the affidavit. I don't know why. Page 10. Directly. Now bear with me. And while saying that at page 10, he adds multiple other conditionalities that the plot is now again under challenge. Now what happened, Malas, was Malas, para 12 below the table. Give me 2 minutes more. I want to just complete in 2 minutes more. My lords pushed it 2 years against me. Now today he does two things. At page 12 below the table, he says, give me the rate of 2019 as per Justice Narasimha's bench order. But
what are you aiming at?
Give me a minute. But add 30%. Add 30% what he says. I had agreed to 19. He took time to say whether he can agree to 19.
If they are saying that you will take this plot number 11.
2019, I'll take it. I will take it to my detriment at 2019 rates in deference to what fell from my lord.
The whole thing is about the rates, right? Which year's rates are
correct, but not in the argument.
What have you said here?
Argument. His argument. Identity is gone. Now, what that man who they cancelled has filed a second bite fresh writ.
In this
which they don't need to entertain. But they are now entertaining that writ.
Court is entertaining.
Saying, of course you are entertaining. You are trying to put that writ to the court to say, the man whose plot was cancelled here.
Where is the reference?
Has filed a writ now.
Plot?
I can't allow the plot to Mr. Singhvi.
Dr. Singhvi, where is this plot referred to in this affidavit?
Yes, page 16, no, page 10 of the affidavit. Page 10.
What have they said? Just show.
Yes, may I read that? The above reserved price of 61,000 and 11. So, the two rates are 61, but that's wrong actually. It should be 66 for 19. Your lordship asked the rate for 19.
I mentioned
that's 66. Now, just bear with me. Let me answer this question, lordship. Just. What are you showing? You're always showing the wrong thing. This is wrong. Give me the 30% thing. You don't know. You are just always just. Now, Malas, he's saying. He's saying 1,10,000 plus 30%.
Worked out.
Plus 30.
As per rule 8.
No, he's saying 1,10,000 plus 30. All your lordship had to do is to say that I will pay 110 and the matter is over. He again adds 30%. And in arguments, he adds that the chap whom he cancelled years ago has filed a writ. As if the writ has stopped him from giving it to me. Under Supreme Court order.
1,10,000. That is 1920 rate, right?
That's right.
So
So your lordship did the maths, well, the lordship did the justice. Now it's being reopened for arguments after he was told not to be.
Dr. Singhvi, please, I think you.
No, but this is not
Well,
fair.
I can-
This is for authority to say all this.
All
again.
money matters.
I may just say this,
So-
as an officer of the court, I'll say this.
No,
Your lordship had said on the last date, it was his offer, make it 1920 and add whatever interest, etc.
You give
Today,
it's as simple as
today it is
this what
far more than 2 lakhs.
We'll just close
26
this.
minutes.
Mr.
He's closer to
we don't
19
do
rate,
anything.
it's double.
It was maybe windfall, all right, doesn't really matter. But then there is an order of this court. Right
He was
or
to give
wrong.
market value.
Right
He has
or
not paid. He has
Okay,
wanted.
we are going to direct now. We are not going to entertain any further argument on
Absolutely,
this.
not
We
difficult.
will direct you to give this plot as is where basis, because we don't know the litigation. He says
Yes,
that there is no
absolutely.
litigation, so we'll leave it at that.
Yeah.
We'll give this plot to you to be given to them at the rate of 11,000.
No,
1,08,000.
1,10,000.
It's 110,880 per square meter. Is his own affidavit.
Well,
says so.
I've only pointed
That's it,
out
well, that's
that
all.
even at that time when auctions were
All
done,
this was to save
today it is
30%.
today this works out to about 50 odd crores. Market rate is more than 100 crores because we're in 26.
Obviously, or else why will Dr. Singhvi
And
be
well,
here?
it's exactly. And number one, number two, for a person who has made a measly 16 lakhs, he's today getting a windfall millage of 50 plus crores.
This is a windfall, Lord.
9 years now.
Windfall in a contempt.
Actually, this is, we are not very happy with passing this order with Sun. It's quite
Very frankly, not a we on this side, but we leave it.
coaxing by virtue of a contempt order.
Yes.
That order was in the context of something.
Yes, exactly.
It doesn't matter. But then
But I
court
leave it
order
to
has to
Lordship,
be
because we have no malafide intent at all. Manoj.
Court orders have to be respected.
Yes, absolutely.
Whatever it is, we once order is
In
passed,
fact,
whatever be
we
the
had
process.
offered immediately. They said, no, we don't want this. We want the same scheme, this plot. This was under litigation.
All
then.
right, okay.
Now
The
for all this
present petition, is this an IA or a content petition? What is it?
contempt, Manoj, contempt.
After having heard Dr. Singhvi and Mr. Nidesh Gupta for the petitioner and the respondent, सभी का नाम लिख लेना. We are of the opinion that the present proceedings can be disposed of with a direction that the respondent will be given plot number
Come on now.
11/CP5 at Vikas Nagar at the rate of
Lucknow.
1,10,880 per square meters.
Obliged.
On an as is, where is basis.
On an
As per the installment plan, they themselves offered.
Whatever
They
it is.
themselves offered. No, but otherwise they will again then create a problem. I'm not saying anything myself. As per the installment, allotment letter
As
gives
is
the
where
standard.
we will indicate that, again, another.
Exactly,
situation.
exactly.
Suppose you come and say that they have given encumbered property and all that.
That's why I pointed out.
This should be fair, Malas.
We should be as is where basis, that's all.
Stop there. Full
As is where basis.
Full stop.
Just notice there is a litigation. Just notice that.
No,
As is, where is
no,
can be a physical plot.
No.
Manoj, otherwise,
Cancelled. After so many years, after the Supreme Court starts, they say somebody has filed a writ. There is no stay, nothing. On the same cancellation.
But it is under litigation.
The person who was cancelled,
under
the person who was cancelled has filed a writ.
Mr. Nidesh Gupta says
As is
that there is a litigation which statement is disputed by Dr. Singh.
Yes, very well.
Singhvi saying that there is no writ at all, there is no writ petition pending at all.
No, I'm not saying that. The man who was cancelled by Mr.
Disputes,
Gupta
okay.
filed a writ now. That doesn't mean he can't give me the plot.
It disputes about
That's what I'm
the
saying.
litigious nature of the property. Disputes.
It's an unencumbered plot, but there's no encumbrance of any kind.
Right.
He wants to create an
These
encumbrance. of the
these
mind.
directions, the content petition stands disputed.
Well, as per the installment plan offered, because there's a plan offered by them.
No, as per
As per the
offer, yes.
As per the allotment letter. It's already, all the terms are there, but there are other terms which are
As
not.
per the original allotment letter
Dated
what's the date?
12/4/25. Dated 12/4/25. Within a period, Malas.
They make about 65 crores. Manoj.
This is the way to Malas.
Keep on making.
So the matter is adjourned for a date, for a rate. Then it becomes 65 crores, prejudice your lordship.
We are not at all happy.
Prejudice your lordship.
Dr. Singhvi, we are not at all happy about doing this.
Yes.
We are bound by the court's order.
Or is it 9 years ago, was it 65 crores, Malas? My learned to tell your lordship that
This word is being used to make such orders. It doesn't matter. leave
And it is my duty to point out there is litigation. If we don't do that, there will be
Doesn't
another
matter.
contempt that see
Doesn't
there was
matter.
litigation, they didn't tell
These
us.
are hardly the ways in which we pass orders.
Lordship.
Earlier an order is there, so we have to abide by that.
Grateful.
Item?
This matter is coming after notice, my lord.
Well, it's 56. I have something to say on it.
Say, who
There's
stops you from saying?
suppression in this matter. Well, it's two things. Number one, the direction was to either recruit him.
Petitioner is an aspirant. 1 minute, we'll just know what the facts are.
Yes, I'll just quickly tell.
R3
My lord, other side has not filed any reply, my lord.
It's not required. I'll be.
Not necessary.
They should restrict to the facts only, my
Not necessary.
No new facts should be brought, my lord, because I don't
Party
know what.
will with his contempt petition before the High Court.
God, I have a meeting to attend.
I don't know what she's saying.
This is your contempt.
We'll take it up. We'll take it up on Monday.
Yes,
It's
my
a
lord.
very.
We'll
small
take it up.
matter.
We have a meeting
I leave
to
it to the
attend.
court minutes. Very
We
well.
have a meeting to attend.
Very well minutes.
Monday.
Please.
This Monday or my lord coming?
Friday.
I
Put it up on Friday.
Please, my lord.
Bolo?
Please, minutes.
58.
This matter, your lordship has been pleased to issue notice and counter has been filed, my lord. Now, my lord, this relates to recruitment in police, my lord. In view of the advertisement of
Take it up on
2017.
Friday. Put it up on Friday.
Lordship.
Please, minutes.
Next.
My lord, then kindly place this after Friday, my lord.
Okay.
We will file our rejoinder.
After 2
also.
weeks. After 2 weeks.
I filed way back. More than 3 months they had to file rejoinder. Now they're
After
seeking
2
time.
weeks. We'll have it next week. Don't worry.
Next week, please, minutes.
Next.
Right.
Grateful.
Second round in Supreme Court. Huh?
Well, this is the fourth
This-
round, my lord. I must clarify.
What
Fourth
is
round
this?
before the Honorable Supreme Court, my lord. But, my lord, I will also.
Absolutely unjustified.
Lord,
fight.
may I just, my lord, I understand that this is the fourth round.
With costs, huh?
My lord, after hearing me, my
kind
lord,
of it.
after hearing me, my lord, I'm only requesting for a, my lord's hearing of 2 minutes, my lord. Kindly permit me
The
that.
time starts now.
Grateful, my lord. My lord, this is the fourth time I have come to the Honorable Supreme Court. First time I came against the order of the appellate court, whereby, my lord, 2 decimals were extra given. It's a suit for partition, my lord. I was a defendant in that. Now, my lord, that was set aside by this Honorable Supreme Court in November, my lord, in 2011. Second, my lord, SLP was filed saying, my lord, that the decree is inexecutable because once the decree was modified by the order of this Honorable Court, a fresh decree ought to have been prepared, my lord. But that was not drawn, my lord. So Honorable Supreme Court, my lord, held in 2016 that the order of the High Court is correct and the decree can be executed. Now, my lord, third round was, my lord,
Trial court suit. Huh?
Lord's third round was again on the point, my lord, that it is inexecutable. So Lordship on 30th of April 24 said that no, the order of the High Court is correct. Now, my lords, today I have come to your Lordship not on the part of executability of the decree. I am on the ground, my lord, that insofar as the execution of the decree is concerned, my lord, in a suit for partition, Order 26, Rule 14 says, my lord, that if a local commissioner is appointed, he prepares a report, then, my lord, the party has to be given an opportunity to file his objections.
Minutes is over.
My lords, I have not been heard.
Dismissing with
My lord, with great respect, my lord. I think 30 seconds are there.
Dismiss with cost.
My lord, will kindly permit me, my lord. Kindly show me.
50,000 rupees.
Allow me to show, my lord. My lords, I have not been heard. I have not been heard. Kindly have.
How much we are not even stating the kind of litigation that
my lord, will kindly
original
see.
decree of 1994.
That is correct, but it has to be executed in accordance with law, my lord.
3
I'm only on
rounds
law,
of
my lord.
litigation.
I'm only on law. If kindly,
Dismiss with cost. Take a next call, the next case.
if lordship will kindly bear with me, my lord.
18. I know.
Kindly see, my lord. But
Nothing,
what has been given to the decree holder, my lord, is the portion which
have
is on
to pay the costs to be paid to the Supreme Court Bar Association.
My lord, will kindly,
Next.
since my lord is imposing cost, my lord, kindly, my lord, bear with me, my lord. Lordship will kindly bear with me, my lord.
Okay.
My lord, kindly bear with me.
Hearing is as per cost, is it?
My lord, no, my lord. So I'm only
We'll
requesting.
increase it.
I'm only requesting, my lord. Here is the case where the trial court, executing court, as well as the High Court, my lord, says that I have been heard on my objections. Kindly see the order. The possession has been handed over on 27th of April. The pleader commissioner files his report on 27th of April. I'm not heard on 27th of April 24.
We have remanded it earlier after
No,
everything.
with
We have
great
seen every
respect.
part of it.
Not on this, my lord.
The 50,000 rupees cost. Next.
My lord, 30th April.
All right.
Lordship, kindly, my lord.
Enough. Next.
Grateful, my lord. But if Lordship will kindly.
No question. No question.
My lord is.
The cost will remain.
My lord, 30th April order was passed, my lord. Grateful, my lord.
To the Bar Association, you will have to pay. Next.
Next.
Further.
Lords, your Lordship's judgment of Indira Sani, Lords, directions in Indira Sani, Lords. Complete violation. Complete violation.
Yeah, go to the High Court.
Lords, I went to the High Court, Lords. I came to your Lordship's first.
There is no contempt here.
There is a, because this is the violation of your Lordship's direction in Indira Sani's judgment, Lord. Just give me 2 minutes, Lord.
So every Supreme Court judgment will come contempt here.
2 minutes, just 2 minutes. I'll just demonstrate, my lords. Your lordship's violation of your lordship's directions in Indira Sani, my lords, which prompted the writ petition. Writ petition also, my lords, they said that yes, there is a violation. You have to implement that, my lords. Then the state came over in appeal. Your lordships gave 1 year's time. That was in 2021, my lords. 5 years have passed, my lords. Your lordship issued notice in this.
Where?
Lordships.
Where can't be a contempt.
I'll just five pages in this, my lords. Just 5 pages. Just 5 pages, my lords.
You're not entertained.
My lords, just 5 pages, my lords.
After having heard Mr. Harris Piran, Leonard Senior Counsel, appearing on behalf of the petitioner,
Because
we are of the opinion
it's a serious
that
matter.
there is no contempt of the order passed by this court, as the order merely directed, mild directed extension of time granted by the High Court. Full stop. While we dismiss the content petition, we leave it open for the petitioner to avail other remedies as may be available to him. Next.
Great. My apologies, Mulot. I was actually on my legs before court.
What is this?
Mulot, I am neither the borrower, I am not the guarantor, I am not the person who has anything to do with Shriram Finance. But what happened is this. Grateful.
He has done nothing to do. He's somebody, the catchword of his plot, and then there's no interim order, right?
No, my property they may not put to sale. I have nothing to do with.
Pending disposal of the special leave petition, the property in question shall not be put to sale.
Grateful.
Shall not be encumbered.
Lordships.
Any further.
Lordships. Great.
If I can speak, my lords,